Good morning. Welcome to another insightful program, which we have entitled HRLAW Kenya. Today, we are going to have an in-depth analysis of the various labor laws that are in operation in Kenya that regulate the employment relationship. I want us to imagine a situation or an organization where there are no labor laws that govern the employment relationship. That environment will be very chaotic. The HR functions cannot be performed effectively. There will be unfairness. There will be very many conflicts and very high rates of employee turnover. And this is the very reason why we should be able to understand the various labor laws that regulate the employment relationship, which will help us, one, to avoid lawsuits, penalties, and fines, which are very common in many organizations in cases employees go to court. And for today, we are going to look at the core labor statutes that govern the employment relationship, as well as the supportive statutes that provide various regulations and guidelines on how we can employ, or how we can manage the employment relationship. I am your presenter, Andrew Ondari, and with me to make this program very interesting and insightful, I have Mr. Paul Bonyo, who is a legal expert, a trainer, and a consultant. I believe many of us have known him for some time, especially those who have attended our trainings. Mr. Paul Bonyo, if you can hear me, please say hi to the participants.
Good morning, everybody. My name is Paul Bonyo, and I'll be a resource person in this program today. Thank you.
Thank you, Paul. And without much ado, I want us to move to our introduction of this program today. But before we do that, I will go through the main topics that we shall be covering today morning, starting now up to 11 o'clock or thereby. The first topic is the Kenya Employment Law Essentials, which basically focuses on the core labor laws, such as the Mother Act, which is the Employment Act, the Labor Relations Act, the Labor Institutions Act, among others, for purposes of ensuring that we are compliant with the basic requirements of labor laws, especially when it comes to the various functions of HR, like recruitment, training, performance management, termination of employment or disciplinary and employee relations issues. Secondly, we shall be looking at disciplinary and performance compliance, where in disciplinary we shall be relying on the Employment Act, which provides the guidelines on how disciplinary actions are conducted and managed. Performance compliance is very important because this is where the rubber meets the road. That without performing employees, then the organization cannot achieve its strategic objectives. And there is a linkage between performance and discipline, in the sense that discipline relates to committing of an offense for which actions can be taken, and therefore investigations are required. And for performance, there are no investigations, but we rely on performance appraisal records. And the main aim of performance management is to ensure that the employee improves and is not for disciplinary purposes. So that distinction should come out as we move on in this topic. And then lastly, we will be looking at the ELRC, which is Employment and Labor Relations Court, case law, and risk management. Why do we need to look at these cases? It is because they will give us insights on what organizations can do that can cost them a lot of money in terms of lawsuits, fines, and penalties, especially when the employer loses the cases. We have lined for us a number of cases which my colleague, Mr. Paul Bonyo, will handle and see what happens in some of these cases, especially when due process has not been followed. And then on HR risk mitigation, we are looking at failure to follow the legal procedures can cause risks. So failure to comply with the various labor laws can pose risks to an organization. And what are these risks? One are lawsuits, which are very expensive. Two, fines, which sometimes courts impose on organizations. And lastly, penalties. And these are the ones that we have to avoid if we have to support our organizations achieve their objectives. Having said that, I want us to move to the first part of our discussion today, that is the Kenya Employment Law Essentials. And in these essentials, we are looking at the relevance of the various employment laws with respect to human resource management. And in our introduction, the HR law provides the legal framework which governs the employee-employer relationship. We are all aware that without law, the rule of the jungle takes over. The working environment will be very chaotic, there will be unfairness, and there will be injustice. And for that reason, we need a legal framework that governs the employment relationship to ensure that employees are treated fairly and there is order in an organization, and that everybody, and by everybody I mean junior staff, middle managers up to senior management, must comply with the labor laws. There's no exception to compliance when it comes to the various labor laws. So the legal framework is provided by the HR law, which most of us are aware of, and we shall give an overview of those laws for purposes of emphasis. Secondly, the labor law helps to protect organizations from risks and compliance risks. That in risk protection, we are preventing organizations from lawsuits, especially where there is unfairness. And unfairness might come at any point in the employment relationship, including the time for hiring. If we don't comply with the law, especially the Employment Act, where non-discrimination is provided for, an aggrieved employee can go to court and sue an organization. Penalties are generally used as those decisions that are made by the court as a way of ensuring compliance if an organization is not compliant. And that includes fines for not complying or compensation for employees who have been unfairly treated, such as unfair dismissal. And by adhering to the HR law, we ensure that everybody adheres to the labor laws in our organizations. Thirdly, HR law ensures fairness and employee protection. That employees should be treated fairly, even from the time they join the organization to the time they leave or exit. That much as an employee is exiting, they should be treated fairly, especially when they resign voluntarily. There are organizations that are unfair to their exiting employees in a way that they violate their rights. And that fairness is ensured through this HR law. Talking of procedural justice, and we shall be referring to Section 41 of the Employment Act, where due process is not followed by the employer. And this is one of the main reasons why employers lose cases in a court of law because of failure to follow due process. Meaning that procedural fairness is not an option, but a requirement by the Employment Act. And again, through fairness, there is improved trust between the employee and the employer. That the employer respects the law as well as the employee. And when there is fairness, there is improved trust between the two parties. And lastly, on fairness, employee morale is improved because people are treated fairly, meaning that they are likely to be motivated to stay in the organization for a long time and also perform their duties effectively. The other aspect which is important in this discussion is organizational discipline and consistency. That by adhering to the HR law, we standardize our HR decisions, especially on matters to do with hiring, whether it's a new hire or a promotion, a transfer, a reward, or a disciplinary process. So with effective compliance of the labor laws, we standardize our decisions. And basically, standardization is in the form of HR policies, which are derived from the labor laws. And also, the labor laws help to prevent bias, where managers can make decisions which are favorable to them and unfavorable to the employees. So through this standardization, biasness is reduced, which in effect promotes equality. And then lastly, on organizational discipline, that through the HR law, the workplace management is well structured. By structured, we mean, one, procedures are followed so that there is a structured way of working. Two, when it comes to discipline process, and that process gives structure to the disciplinary management process. And even in other areas like compensation, for example, an employee has been injured under Work Injury and Benefit Act, there is a procedure to be followed so that an employee is compensated adequately. And then another important aspect is conflict resolution in relation to HR law. That, for example, the Labor Relations Act, the Labor Institutions Act, as well as the Mother Act, which is the Employment Act, provide mechanisms for dispute resolution. And with such labor laws, there are reduced disputes, and they provide mechanisms for mediation, especially when the two parties cannot agree. And the conciliators, who may be appointed by the Ministry of Labor or the CS for Labor, neutral third parties, to reconcile the employee and the employer where there are conflicts or disputes. And in this way, we promote a stable labor environment where there is peaceful coexistence between the employee and the employer. And then lastly, labor laws allow for adaptation to modern work environments. For example, today, especially after COVID-19, we started working remotely. Despite the fact that employees are working remotely, there are laws that are in operation which regulate this relationship, that both the employer and the employee still employ the regulations and the laws provided under the Employment Act, the Labor Relations Act, as well as WIBA, Work Injuries and Benefits Act. So ladies and gentlemen, that's our brief introduction to the need to understanding the HR law in Kenya. As part of understanding what we have called Kenya Employment Law Essentials, let us now look at statutory framework. And in this statutory framework, we are looking at the structures, systems, policies, and processes that are involved in promoting the employee-employer relations, just like I have said from the introduction. One, there is the concept and scope of this statutory framework. This defines the employment relationship, rights and obligations of both the employer and the employees. And I will be discussing in a little while the rights and obligations of both parties. That in this framework, which we have called the labor law, we are talking about the relationship between the employer and the employees. And this relationship should be cordial or harmonious in nature. How? It's through the promotion of democratic principles where there is participation in decision-making, mutual respect, and effective communication. For example, when it comes to disciplinary process, the employer must communicate by way of a notice the offenses that the employee is alleged to commit, the nature of the offenses, and the labor laws that have been violated. And this is in the spirit of promoting a good relationship, that employees must be made aware of the offenses that they have committed, and that's part of communication. Both the employer and the employees have rights. For example, the employee has a right to be paid according to the contract and has a right to leave, either annual leave or paternity and maternity leave. And all of them have obligations. For example, the employee has an obligation to do work for which he or she has been assigned. And the employer is obligated to pay the employee and also create an environment which promotes the employees to work well. And then the legal framework also provides the minimum standards in regard to wages, hours, and leave protections. For example, wages, the Employment Act stipulates the minimum wage that can be earned by certain cadres of employees. And as a general minimum standard, the workday starts at 8 and ends at 5, which means that there is an 8-hour workday beyond which an employee is entitled to overtime, which is usually twice the hourly rates. And then talking of leave, there are various types of leaves that employees are entitled to as a minimum standard. And these are statutory, which means that they are contained in law. Annual leave, sick leave, paternity leave, and maternity leave are basic minimum requirements provided for in the Employment Act. Talking of safety, safety is covered in 2 basic laws. One, OSHA, which is Occupational Safety and Health Act, as well as WIBA, Work Injury Benefits Act. That as employees, we have a right to a safe working environment free from accidents. And it's the responsibility of the employer to create that safe environment where employees are not injured, and that requires the employer to ensure employees have protection or protective gear. The work environment does not have conditions that may expose the employee to injury. And then there's the element of procedural guidelines. Like I indicated, procedural guidelines has to do with processes in relation to hiring. We all know the process of hiring starts with identification of a vacant position all the way to onboarding. Particularly during selection, an employee may feel discriminated when it comes to hiring. And unless we follow due process, an employee can go to court and sue the prospective employer for discrimination. The Employment Act, as well as our Constitution, requires that all qualified candidates be given equal opportunities for employment. And this is where procedural guidelines are given under the Employment Act, which ensures that all eligible employees are given equal opportunities to work with the organization. There is also a procedural guideline on discipline that as a basic requirement, the employer must furnish the employee with a notification indicating the offense that the employee has committed and the consequences of those offenses. After the notification, the employee is given a fair opportunity to prepare for the case. 2, 3, the employee attends a disciplinary hearing 4, the action is taken commensurate to the offense. And lastly, the employee is given an opportunity to appeal. That is the process in the disciplinary guideline provided for in the Employment Act. Failure to follow this procedure may amount to unfair termination, and the employee has liberty to go to the court to seek redress. On matters termination, and termination can be voluntary or involuntary, there are procedures that are provided by the Employment Act so that none of the parties violates the law. Where there is voluntary termination, the guideline is that the employee must give a 1 month's notice, or if not, they pay in lieu of notice and vice versa. Dispute resolution is another procedural area that is guided by law, where an employee or a group of employees are aggrieved and they launch a complaint. So the complaint must be recorded, investigated, and a decision made. And these disputes usually arise in organizations, especially those organizations with trade unions. Where there is a trade union, there might be a disagreement between them and the employer, and the Employment Act, as well as the Labor Relations Act, provides mechanisms for dispute resolution. Another aspect in the statutory framework is regulatory institutions. And this is governed under the Labor Institutions Act, and it provides for courts such as ELRC, that is Employment and Labor Relations Courts, which become arbitrators in case of disputes to ensure fairness in dispute resolution. There are tribunals that are provided for under the Employment Act and the Labor Relations Act, where disputes could be taken to tribunals for redress. In the Work Injuries and Benefits Act, as well as OSHA, there is provision for inspectors from the Ministry of Labor or to come to the organization to inspect the working conditions to ensure that organizations are compliant. So there are those institutions which are regulatory bodies and administrative frameworks which ensure that there is fairness, equity in the way decisions are made in organizations, especially on matters discipline, on matters termination, on matters hiring, and even on matters performance. And then there is another aspect in this framework, which is covered under the various labor laws, and that is the legal foundations. And these constitute or incorporate constitutional principles, international conventions, and equity within organizations. Talking of constitutional principles, and this is derived from the Constitution of Kenya 2010 on the Bill of Rights, that an employee has a right to a safe working environment, a right to fair treatment, a right to fair termination, and a right to assemble and participate in lawful processes. Those rights are not negotiable. For example, the right to join a trade union of preference or a right to picket. Those constitutional rights cannot be taken away from the employee. Even the Employment Act also talks about the rights of the employee, including the right to fair treatment and the right to a safe working environment. Those are legal foundations in relation to the Constitution. On international conventions, we are referring to ILO conventions mainly. And some of these conventions relate to the right to join trade unions, to prevention of child labor, and also the right to administrative justice. All these are contained in the various conventions of the ILO. And my colleague, Mr. Paul Bonyo, will highlight some of these conventions that regulate the employment relationship. And because they are ratified by the Kenyan government, by ratification, we mean they have been agreed upon, and therefore they should be applied here in Kenya. And this is where some of our labor laws are derived from. And lastly, equity, which is about fairness in employment relationship, that in terms of hiring, there should be fairness. In terms of discipline, fairness. In terms of termination, fairness. So those are the legal foundations as contained in the various labor laws, such as the Employment Act, the Employment Relationship Act, the Work Injuries Benefit Act, among others. And then lastly, these laws provide enforcement mechanisms that in case of violations, what should happen? So the various statutes provide for penalties, remedies, and sanctions. So penalties could be in the form of fines, which an employer might be required to pay either to a regulatory institution or to the employee in the case of a violation. And then remedies are decisions that are taken by the court in favor of either the employee or the employer. And one of the remedies could be reinstatement or compensation of an employee in case of unfair termination. And then sanctions could be restrictions imposed by the court to prevent future or similar actions in the future. So these are the key statutory frameworks that relate to the various HR law. As I indicated earlier, our discussion will revolve around the core labor statutes as well as the supportive statutes. We will start with the core labor statutes. And after that, I will invite us to ask questions or make comments so that we move together. One, there is the Constitution of Kenya 2010, particularly Article 41. All labor laws are derived from the Constitution, and therefore it's the supreme law which everybody, including the president, must follow. So in the Constitution 2010, and particularly Article 41, the Constitution guarantees fair labor practices and rights. And there are various practices, for example, an environment free from injury and illnesses, which means that there should be an environment where the employees are not injured or do not fall sick because of those practices. 2, fair treatment when it comes to recruitment or hiring, or when it comes to disciplinary procedures. And then the rights, the right, for example, to appeal when the employee is not satisfied. And we'll be talking about appeals, especially in relation to the Labor Relations Act, where a decision has been taken by the employer and the employee appeals to a higher authority. For example, those of us working in the public sector, when an employee feels unfairly treated or a decision has been made which violates his or her rights, he or she has a right to appeal to the Public Service Commission for redress. And after the Public Service Commission, if the employee is not satisfied, they can go to the ELRC, that is the Employment and the Labor Relations Court. And that is provided for under the Constitution 2010, Article 41, on matters fair treatment. Secondly, the Employment Act, which in HR we call the Mother Act, which governs the employment relationship in Kenya, not only in the public sector, but also in private sector. There is no exception to this. So among the provisions in the Employment Act include the employment contract, that there should be a written contract given to the employee indicating the terms and conditions of work as well as payment. 2, the Employment Act also provides procedures for disciplinary action. It also provides guidelines on termination of employment, and also provides guidelines on hours of work as well as wages and salaries. So we must have a clear understanding of the Employment Act. Thirdly, there is the Labor Relations Act. And I should mention that all these acts are 2007, and others have been amended 2020, 2024, 2025. The Labor Relations Act regulates trade unions, employer organizations, and collective bargaining. Trade unions are bodies that represent the employees to the management on employment matters. And these employment matters may relate to salaries and wages, hiring, working conditions, as well as wages and salaries. So these trade unions are legally provided for under the Labor Relations Act. And they are independent bodies that can be sued or can sue, but they represent the employees of the organization, and they should be voluntary, meaning that the employer is obligated to recognize a trade union if the employees are willing to join a trade union of their choice. Employer organizations, these are organizations that represent the employer so that they can protect their rights and also their businesses. There are a number of these employer organizations that we may all know, and this includes the Federation of Kenya Employers, or Kenya Chamber of Commerce, which protects the business of the employers. So these organizations represent the employers at various levels so that they can protect their business and also ensure that they are treated fairly, especially when it comes to disputes before courts of law. And then lastly is the collective bargaining, where collective bargaining involves trade unions which bargain with the employer on matters that I've mentioned, such as salaries and wages, working conditions, promotions, as well as performance and disciplinary matters. This collective bargaining involves negotiations with the employer on those matters, and an agreement is reached. According to this act, the agreement should be registered with the ELRC for it to be binding. And any party that violates this agreement can be taken to court, and the court can award either the employer or the employee, depending on the merits of the case. And then there is the other Core Statute, which is the Labor Institutions Act. And I indicated these are statutory bodies or administrative structures that help in the management of employee-employer relations. I have mentioned some of these institutions, for example, the wage councils, to the Employment and the Labor Relations Court, as well as other bodies which can come in when need arises so that they can help either to arbitrate, mediate, or reconcile the parties involved, that is the employer and the employees. Occupational Safety and Health Act is another statute which ensures that the workplace is safe and healthy. As it were, safety relates to the protection of employees from injury. So all conditions in an organization should be such that they prevent occurrence of accidents. And in relation to health of employees, that there are certain minimum standards that must be put in place by the employer to ensure that employees do not get sick in the organization. For example, ventilation as a minimum standard, there should be adequate ventilation. 2, the working environment must be clean. 3, there should be adequate space in the workstations of the employees so that we prevent communicable diseases. And there should be adequate breaks for employees to stretch. and ergonomical issues that arise in the organization which can affect the health of employees. On matter of safety, the employer is required to provide protective gear such as helmets, overalls, and gumboots so that the employees are not injured. 2, the employer must maintain all machinery, hoists, and levers so that we prevent accidents. And lastly, there is the Employment and the Labor Relations Court, to which most employees go to arbitrate when there is a dispute. This court is important because it interprets the law and ensures enforcement when there are disputes between the employer and the employees. This court has powers to sanction the employer, to reinstate the employee, and also compensate the employee depending on the merits of the case. In cases where the employee has committed an offense and the employer has followed all the due process, the Labor Relations Court can maintain the decision made by the employer, which means that the employee loses the case. And that means that the employee might also pay the costs of the case. So it works in both ways, where the employer has committed an offense and the court proves that the decisions were unfair, there are remedies. And if the employee committed an offense and a fair decision was made, and again, the court will agree with the decision and award the organization accordingly. So ladies and gentlemen, those are the core labor statutes that all of us should be aware of or understand for purposes of ensuring fair and conducive work environment in our organizations. On that note, I would now like to invite any one of us with a question or a comment to make in relation to, 1, the introduction to labor law, 2, the statutory framework, and 3, the core labor statutes before we go to the supporting labor statutes. The floor is ours. If you have a question or a comment to make, please go ahead.
Thank you, Andrew. I have maybe I'm requesting for a clarification.
Yeah.
Under statutory framework.
Mm-hmm.
When you are discussing minimum standards,
mm-hmm.
I seem to have heard you say overtime is twice the hourly rate. Is it for all, whether it's a weekly overtime or a public overtime? Is there a change? And then I was also requesting under procedural guidelines, if you can just repeat the disciplinary procedure, I would appreciate that. Thank you.
Okay. Thank you. Kindly remind us your name.
I'm Consolate Adamson.
Consolate.
Yes.
Thank you, Consolate, for your question. I will start with answering your question and then invite my colleague, Mr. Paul Bonyo, to also make a comment. You talked about payment of overtime and public holidays. And secondly, you talked about the disciplinary process that should be followed by the employer. On overtime and public holidays, it's a legal requirement, particularly the Employment Act, that an employee should be compensated twice the normal rate when it comes to overtime and also holidays. And the holidays include all the holidays that are recognized in law under the Employment Act. On matters discipline, the process is provided for under the Employment Act. That one, the employee should be furnished with information related to the offense he or she is alleged to commit. That is a notification. Two, preparation. Allow the employee to prepare to attend a disciplinary meeting, depending on the offense. Number three, the employee is given a fair chance to defend themselves. If the employee does not provide adequate explanation for the offense, then a disciplinary action is taken, commensurate with the offense. So disciplinary action. And after the disciplinary action, then the last step is appeal, where the employee has an opportunity to appeal to a higher authority to have his or her case addressed. So those are the basic procedural aspects that should be followed, particularly under the Employment Act. Mr. Bonyo, if you have something to add, please go ahead and do so.
Maybe before he adds, I would request that clarity is made, because if a person works overtime, say on a Monday or Tuesday, in the course of the week, I think we've not been paying twice the hourly rate. We're paying 1.5 times. And when it is a gazetted public holiday or a Sunday, that's when we do twice the hourly rate. But from what you're telling me, I wanted to understand, is it now twice the hourly rate, even if a person worked overtime in the course of the week, say on a Monday and a Tuesday or Wednesday, Thursday, they've exceeded the 8 hours, they've worked 10, so the additional 2 hours that they work, we would double the hourly rate. That's what I want to understand. Is there a change, or we still do 1.5 times in the course of the week, and only the public holidays, then we double the hourly rate?
Okay, thank you, Consulate. Yeah, during public holidays, usually the payment is double the hourly rate. And again, depending on your policy, where an employee has worked overtime during the week, you can pay 1.5 times the normal rate. Or if you want to be fair to the employees and promote their morale and motivation, you can pay them double. So that again depends on your policy. Thank you.
Thank you.
Mr. Bonyo.
Thank you, Bwana Andrew, and all the participants. I would like to approach it from a different angle. On Consulate's question on minimum standards on overtime, the law provides that if an employee works overtime during working days, that employee is entitled to 1.5 hourly rate, 1.5%. That's 150% on the hourly rate. That is correct. And if that's what they have been practicing, they are in order and they are within the law. But if an employee performs overtime work during weekends and public holidays, that employee is entitled to 200%. That is twice the hourly rate of payment. So that is the legal position. But as Mr. Andrew said earlier, the Employment Act provides for the basic minimum terms and conditions of employment. So if the employer is generous enough or sufficiently philanthropic, that employer can give more, but not less than 1.5 for weekdays and 2 for weekends and public holidays. That is the legal position.
Thank you, Paul.
Thank you.
Consulate, if you have a further question, you can go ahead.
Yes, I wanted to ask if the employer opts to compensate the hours worked by giving an employee maybe a free day later, is it okay?
Paul?
That is not provided for in law. That is like asking an employee, for example, that I will forfeit your leave days. I will ask you to forfeit your leave days and pay you cash instead of leave days. It is not permitted by law. Overtime must be paid as per the salaries per hour, not as per the extra time you want to give in terms of leave or off days. So if that has been practiced somewhere else, it may be a private affair acceptable within the parties. But if the matter goes to court for legal interpretation, the court will not accept the idea of replacing money for the salary with the leave days or off days. Thank you again.
Thank you,
Paul.
I wanted to say something on the process, the procedural guidelines on the disciplinary process. The first step is the show cause notice. It is called NTSC, notice to show cause. After that, the employee will be given a chance to respond. After the response, if the response is not adequate, as Mr. Andrew said, then the person will be given further notice to appear before the disciplinary committee. Once appearance takes place, the next step is that the employer will be required to state its case against the employee. That employee will be allowed now to respond on the plenary. While responding on the plenary, the employee must be accompanied by either a friend, a fellow workmate, or a union representative. That representation is important, and if it is skipped, the entire process becomes a nullity. After response by the employee, then the next step is that the panel will be allowed to ask questions. Then after clarification, then if there is any gray area, then the parties may be allowed to give their views, after which the panel will retreat to make a decision. Once a decision is made, that decision must be made in writing, and that decision must be communicated to the employee in question. That decision must be very clear in terms of the decision made, the reasons for that decision, so that the employee can be able to appeal based on those reasons. And then finally, the verdict will be made as to whether the employee is guilty or not. Thank you, Andrew.
Thank you, Paul.
Excuse me, Paul, is there a time limit for preparation when you have given notice to the employee?
Notice to show cause, normally it begins from 3 days. Depending on the nature and magnitude of the issue at hand, it commences from 3 days and more.
So if the employee can take 30 days, they are still preparing their defense. Is that okay?
Depending on the nature of the problem. Because some problems are so complicated that a lot of time is needed for purposes of preparation. But the law talks about reasonable time, which begins at a minimum of 3 days.
Okay, thank you.
Thank you very much, Paul. Thank you, Consulate. I will now move to the next part, unless there is a question or a comment to be made by any one of us.
I have a question.
Helen, I saw your hand raised.
Yeah, okay. I think we are going in a very high speed. I just wanted to comment on the overtime. The overtime also, we should also refer to our overtime policies, where policies say that you can be compensated with the days. Like, for example, in my organization, when you work on Sunday, I give you 2 days as a compensation, but this is indicated in the overtime policy.
Thank you. Anybody else with a question?
May I just respond to that? As I said earlier, if there is a private agreement as a matter of policy with the employee and the matter does not escalate to court, there is no problem. But if the employee goes to court that I do not want to receive off days and I want cash in respect of the overtime I performed, then the policy cannot override the act, the law. Policy statements must align with the Act of Parliament, that is the Employment Act, as well as the Constitution as the supreme law. So when it is a private issue between the parties as a policy and the employee within the organization and nobody complains, there is no problem. But if a complaint arises, the act will override or supersede the policy. Thank you.
Thank you, Paul. Next is Marie. Marie, if you are there, I can see your hand up.
Okay, thank you. My question relates to OSH. Companies are supposed to conduct audits. How frequent should the audits be performed, and how long can you keep the same auditor?
Yes, it's a requirement under the OSH Act that companies must conduct audits, preferably by the Health and Safety Committee. And again, this is governed by your policy that you can conduct audits either biannually or annually, so that you ensure compliance with the Act. As regards regularity, it is up to you now as an organization to determine how many times you can do that, either annually or biannually, or do it at the same time you are doing the internal audit, so that you are on the safe side of the law. It can coincide with your internal audit depending on your policy. But the basic minimum required that there should be an annual audit for every organization with regard to health and safety issues.
And about the auditor, how long can you keep the same auditor performing the audits?
And again, this is regulated by your own policy. If you have an internal audit team, these are permanent people who should be doing the audit on a regular basis. But if you are getting an external audit, again, you will, in your TOR, indicate the duration they should take to conduct the audit. Thank you.
Thank you.
I think she was meaning can you have the same auditor every year, or does the Act provide that if you've used a particular audit for 2 years, then you should change and have a different audit, external auditor?
I think as long as the auditor is under the approved auditors, you can use them as much as you want. And also for the audit is normally annually. The certificate runs exactly for 1 year. So after 1 year is not valid.
Thank you. I think we are guided.
Thank you.
Asante sana. Now we go to the next part. That is the supporting statutes and regulations. By supporting statutes, we mean these are acts of parliament that provide more information or support the core labor statutes so that the work environment is managed in a way that promotes fairness and equity. And I don't mean that they are subsidiary to all the other acts, no, but they guide organizations or the employers on what should be done, when and how, when it comes to matters outside the core labor statutes. To start with, we have the Work Injury Benefits Act, and this provides guidelines on compensation when an employee is injured in the organization or during working hours. For example, drivers, they may not be in the organization, but they can be injured, and that is during working hours. They are entitled to compensation. So the work injury provides guidelines on compensation framework in cases employees are injured or harmed or fall sick during working hours or where they are working. These are diseases that arise from where they are working. Secondly, there is the NSSF Act, which requires employees to deduct from the salaries of employees a certain amount to take care of their retirements when the time comes. I believe we are all aware of the requirements of the NSSF Act, that you should pay 2.7% of the gross earnings of the employees and submit it to NSSF. Failure to which may amount to an offense, and the employee can pay penalties in case they are found guilty. The Social Health Act, which has really caused havoc among employees and employers. This act establishes universal healthcare financing that the employer has to pay for this, for the medical healthcare of the employee, so that the employees can continue working after treatment. Or even if they do not work, but they are financed so that they can reduce the burden. And this act replaces the old NHIF so that all employees have equitable access to treatment. And we are all aware that some of the regulations, including payment on the 9th day of every month, is a requirement, so that we know that if we don't pay, there are penalties that employees will not be covered. Data protection 2019 governs employees' personal data. That as an organization, we are data controllers, and as data controllers, we are obligated to ensure that employees' personal data is not given to third parties. And such personal data may include telephone numbers, salaries and wages that are earned, as well as the health status of the employees. And we all know that if an employer does not protect this data, they can be reported to the Data Protection Commission. And if found guilty for an individual with the data handler, you are likely to pay 3 million. And for the data controller, who is the employer, you are likely to pay 5 million or 1% of the revenues that you have generated over the time. This is a big loss, and that is why we need to protect personal data by ensuring that we process it, store, and treat it confidentially according to this act. And then lastly is the ILO Convention, and these are treaties related to forced labor, which is a form of slavery either for adults or even for children. Non-discrimination, again, ILO Convention requires that employees should not be discriminated on account of age, gender, nationality, and other forms of discrimination. Equal remuneration for work well done, rather for work done, requires that employees be compensated for work done. That if an employee has worked for 8 hours in a month, should be paid such an amount commensurate to that work. Or if it is wages, somebody is paid either daily or weekly, the amount paid should be commensurate to the work done so as to avoid exploitation or slavery. And the worst form of child labor includes forced labor or working to support a family or being forced to work in return for compensation. And even our Employment Act derives this law from ILO Convention so that we protect our children as well as our employees. And Kenya has adopted these conventions, though not all, which requires that all employers must adhere to the Employment Act, which is also derived from the ILO Convention. Enforcement and compliance. This is where we talk about implementation of the various labor laws and what is required for the employer to comply with those statutes. Part of the compliance is the provision of labor officers. And these are people from the Ministry of Labor who visit organizations either with or without notice to do inspections to ensure compliance or conduct investigations in relation to complaints that are presented to them. For instance, during redundancy, the employer is obligated to report to the nearest labor office on the intention to declare some employees redundant. And the labor officers can come to the organization to ascertain whether there are reasonable grounds to render employees redundant. In regard to complaints and disputes, Section 30 to 34 of the Labor Institutions Act provides that labor officers can be looked in to ensure that there is fair and procedural compliance with the Labor Institutions Act, especially where there are disputes between the employer and the trade union. Secondly, there are inspections that should be conducted by the relevant authorities to ensure that the employer is compliant. They can inspect the working conditions. They can examine records related to the employees and then ensure that whatever the organization is doing is compliant with the various applicable labor laws. Where there is non-compliance, the inspectors from the Ministry of Labor, either through DOSH, can also make recommendations on ways of improvement. And if there are no improvements, the organization can be sanctioned and in some cases taken to court. And then there are penalties in the Employment Act, in the Work Injuries Benefits Act, and other acts that we have mentioned, that is the Core Labor Statutes and Support. And these penalties relate to fines, compensation, and imprisonment. Where an employer has violated fair practices as provided in the various statutes, they can be fined. For example, I've mentioned under the Data Protection Act, the employer can be fined 5 million shillings or 1% of its revenues, which can be very expensive, especially those of us in the private sector. Sanctions means that they can be prevented doing certain activities or prevent them from disciplining an employee. It is provided for under the Employment Act and other acts. Where an individual has violated the acts, they can also be imprisoned. For example, if an employee has given out private data related to an employee and is found guilty, if he or she cannot pay 3 million, an imprisonment term can come. And this is under the various relevant labor statutes. Another enforcement and compliance issue is the employer obligations. That as employers, we need to keep records of hiring, records of training, records of compensation, records of disciplinary process, records of termination, and all other records that are relevant to the employment relationship. Failure to keep these records might be very costly to the organization. For example, during performance management, an employee can be put on a PIP. And this PIP means that an employee is given a period of time within which they are expected to improve their performance. As a requirement, the employer must keep records on 1, the name of the employee on the PIP, 2, the position they are occupying, 3, the areas that they are expected to improve, 4, the support required, 5, the resources provided, 6, the supervision accorded to the employees, and all other records. If for some reason the employer has not kept this record, it can be very hard for the employer to defend themselves in a court of law where there are no such records. And if the employee is dismissed on account of poor performance and without such records, the employee is likely to win the case and may be reinstated and compensated for the period he or she has been out of employment. So record keeping in any area of HR is a good practice and mandatory. Otherwise, we might face very difficult times when it comes to court cases where evidence is required. Secondly, an employer is required to give written contracts to their employees, whether it is short, fixed, or a long term. These contracts serve as evidence of employment and the terms and conditions. The Employment Act talks about contracts and the content of such contracts. If an employer does not give a written contract to the employee, then he is violating the employment contract. The other aspect where an employee is obligated to keep a record is pay slips. These are evidence of payment given to employees, especially those on fixed term or permanent and pensionable employment. And lastly, an employer is required to deduct certain amounts of money from the employee's salary as required by law. For example, under the NSSF Act, you deduct. SHA, you deduct. Payee, you deduct. So these are statutory deductions where an employee has no choice but to deduct the amount required from an employee's salary. Failure to conduct or to deduct this might result in sanctions or even fines. The other enforcement and compliance issue is employee protections, that in case of violations, employees are entitled to remedies. These are decisions usually made by the court to ensure that the employee is compensated or is treated fairly. And such remedies include reinstatement, where an employee was unfairly dismissed, he or she can be reinstated. 2, the employee can be compensated if there is any loss on his or her part, or can be paid damages, especially when it comes to the reputation of the employee who has been accused of theft and he or she has been acquitted of such allegations or accusations, because the reputation of an employee has been damaged. So damages for reputation of an employee or an employer. Lastly, the law also provides for alternative dispute resolution, where conciliation and mediation are encouraged. That these are processes outside the court where the employer and the employee can resolve their disputes, especially under the Labor Institutions Act, where a conciliator is a neutral third party who is appointed by the Ministry of Labor to listen to and make a decision in relation to the dispute under consideration. As for mediation, this is a third party agreed by the two parties. Could be an individual or an organization agreed by the two parties who can come and listen. And the work of the mediator is to ensure that the employee and the employer work together to resolve their own disputes, and the agreement becomes binding to both parties. That the mediator does not make a decision, but a conciliator appointed by the court or by the Ministry of Labor can make a decision where the disputing parties do not agree. The second aspect in relation to the labor statutes is contractual integrity. That the employer and the employee are in a contract, and this contract must be entered in a voluntary manner according to Section 7 of the Employment Act. That no party should force another to enter into an agreement in the form of performing a task or providing services. So mutual consent is very important, where an employee voluntarily accepts to work with the employer to provide services. And that speaks to resignation, that as voluntary as the employee joined the organization, the same employee can resign voluntarily, meaning that they cannot be forced to remain in employment against their wish, as long as the processes have been followed by the employee. And that means giving a 1 month's notice in case they want to leave the organization. Secondly, as I indicated earlier, there must be a written contract given to the employee, indicating the terms and the conditions of employment. And that is contained in Section 9 of the Employment Act. This contract is a binding document where the employee and the employer accept to abide by the terms and conditions in the contract. A violation may lead to a dispute, and if not, can be taken to a court, and that becomes a lawsuit, which can be expensive in terms of time and the money spent in this process. And again, matters on non-discrimination is provided for under the Employment Act and the Constitution of Kenya, where all employees should receive equal treatment. When it comes to hiring, equal treatment. When it comes to performance management, equal treatment. Disciplinary, equal treatment. So all employees must be treated equally. And if you don't treat employees equally, then that becomes discrimination, and an employee has a right to go to court and sue the employer. Fair remuneration, as provided for under Section 5 and 17 of the Employment Act, requires that employees get wages for which they have worked and in a timely manner according to the agreement. Fair wages, fair compensation. Like I said earlier, fair wages are contained in the Employment Act, that a person should be paid fairly for a fair day's work. So if an employee was meant to receive 10,000 shillings for work done, and that is the agreement, then the employee should receive exactly 10,000. As my colleague, Mr. Paul, will discuss with us, under case law, there is a case which speaks to an employee getting unfair payment against the employment contract. And when the employee went to court, he was awarded and reinstated because the employer violated the contract. So fair remuneration requires that employee must be paid the amount of money indicated in the contract. And timely, it means on the date agreed, and should not delay unduly. I'm sure there are some of us whose salaries have been delayed for a long time. And if there are deductions, the employees are deducted unfairly. And the benefits given, some benefits are withdrawn without communication. Those are grounds for unfair treatment, and an employee can resign and sue the employer for constructive dismissal. So as employers, we should be careful when it comes to payment of wages and salaries. They should be according to the agreement. It's allowed to delay salaries depending on the financial situation of the organization, but it should be communicated adequately to the employees. Another aspect of contract is the legality principle, that the terms and conditions of the contract must comply with the minimum statutory standards. And again, this is captured under Section 5 and 17 of the Employment Act. It is illegal to deduct employees any money which is not provided for under the law. They must comply with the statutory deductions, particularly minimum wages. And again, some of us have faced challenges, especially when employees have taken loans, and when it comes to deductions, it comes below the required minimum wage, then that becomes a problem. And again, my brother Paul will address this. Lastly, the termination of employment. One of us asked, when it comes to termination, what is the process? The employee can be given notice, a show cause notice, why disciplinary action cannot be taken against him or her. And he or she is expected to respond within a specified number of days. 3 days to a week, that's allowable as long as it is reasonable. And an employee can also give a notice to terminate a contract, that is voluntary retirement, rather resignation. And both parties should respect the notice. But again, I dare mention that in some cases, the termination can come under mutual agreement. But both the parties, employee and the employer, can mutually agree to terminate the contract, and a time period is given within which the contract ends. But for disciplinary, the process must be followed. And my colleague mentioned it very clearly. There must be a notice of show cause, a response, a committee formed so that an employee is given a hearing, a verdict is made, and an appeal is provided by the employer so that employees can appeal to higher authorities. How about breach and enforcement? Breach is violation of any of the statutes we have mentioned, and enforcement is compliance or ensuring that the laws are complied with. And by definition, a breach is a failure to honor contractual obligation. And this obligation is contained in the employment contract. For example, payment of wages and salaries, 2, deductions, 3, disciplinary procedures, and 4, working conditions. So if any of the parties violate their contractual obligations, then the other party can take action. Within the organization, the action could be disciplinary. And outside the organization, could be lawsuits. Another aspect of breach is unfair termination, where an employee terminates an employment contract without a valid reason. And a valid reason here could be indiscipline, 2, poor performance, or a combination of the two. And in law, if a person is not furnished with the reasons for termination, then he or she has a right to approach higher authorities. In the case of public service, you go to the Public Service Commission. And in private sector, you go to higher authorities. For example, the CEO, who might constitute a committee to address your issue. And if not, you go to a court of law, that is the Employment and Labor Relations Court. Another aspect related to a breach of law is constructive dismissal, where an employer creates very difficult conditions for the employee to perform their work effectively. This can be treated as an unfair termination, and the employee can sue the employer for constructive dismissal. Another aspect related to breach is dispute resolution, that there are internal and external mechanisms to resolve disputes. In the case of an internal process, this is where there is a process for reporting and resolving a dispute. That if an employee is aggrieved, he or she may go to a trade union to report the case. And the trade union takes it up and raises it with the management. And the two parties sit and resolve the conflict. And if the conflict is not resolved, it can be escalated to higher levels, including the courts. Externally, where there are disputes, the Ministry of Labor can constitute a conciliator to come and resolve the dispute between the employer and the employees. And where there is dissatisfaction with the conciliator or even mediator, the employee can go to court and seek redress. And then lastly is remedies. These are actions taken by the court to ensure that the employee gets fair treatment or justice. And this includes damages, reinstatement, and compensation, just like I mentioned earlier. What are the rights of the employee under the Employment Act? One is fair remuneration, which is not negotiable. Secondly is a safe work environment, which is free from illnesses and accidents. And that's according to Section 6 and 9 of the Employment Act. Leave entitlements, annual leave. All employees are entitled to annual leave and they cannot be exchanged for any other work. Sick leave of an employee is sick, they should be given sick leave to seek treatment or to recuperate. And again, this is guided by your policy that depending on the nature of the illness, it can range from 1 day to even a month or more. In case of prolonged sickness, the first 1 month, the employee can be paid full pay. The second month, half pay. And the last month, no pay. And after that, a process of exiting the employee can start. Another leave entitlement is maternity and paternity, where maternity is 3 months and paternity is 2 weeks. And this is provided for under Section 28 to 30 of the Employment Act, in case you want to refer. Freedom of association under the ILO Convention and under the Employment Act, as well as the Labor Institutions Act, an employee has a right or freedom to join a trade
Is it just me or we lost the presenter?
I think it is.
Prior.
I think we lost him.
I think we have lost him somewhere and we're working on it.
Okay.
We lost you. I can't hear. We can't hear.
He's coming back, Elizabeth.
All right. Right.
Mwalimu, if you are presenting, you can't be heard. Please.
Sorry, I lost again something here. I want to reconnect. I want to reshare. Okay. Okay, if you can hear me, I was talking about employee obligations. and that is obeying lawful instructions. Can you hear me now?
We can hear, but I think you are doing employee rights. I think you are going to talk about due process.
Yes.
Employee rights.
Let me go back a little. Employee rights.
Yeah.
I think I talked about this. I was on this part of employee obligations,
Okay.
which are the duties of the employee. Obey lawful instructions. That is where I was talking about, and then talked about confidence.
Is it me or even Andrew is hanging?
Maybe we are all hanging.
Okay.
I don't know if Andrew is aware, but I can see we have all hung. Yeah, I'm requesting for an official health break. Give us time to visit washrooms then. Is that okay, Dan?
Consulate, let's give him a minute. I see.
A few minutes for us to go to the washroom is what I'm asking for.
Yeah. Actually, I'll grab a cup of
Okay,
coffee.
thanks.
My apologies, my network seems unstable today. Let us continue. We are now talking about the right obligations of the employee. And now we go to the second part of the discussion today, and that is disciplinary and performance compliance.
Andrew,
Yes, sir.
the last part was never covered. You were not heard.
Okay,
That
let
part.
me go back. Employer obligations.
Actually, we only got the first statement.
Okay, let me go back to the employer obligations. Employee obligations. Thank you, Dan, for guidance. So allow me to go over the last two points so that we can get it. Safeguard employer's property. That means that we use the property of the employer in the right way, and that the property should not be wasted, including money, and there should be no willful damage to this property. If there is willful damage, then disciplinary action can be taken so that the employer recovers the asset that has been lost or damaged. And then lastly, report misconduct, where a fellow employee has committed an offense. All of us are obligated to report to the relevant authorities, starting with the supervisor, so that immediate action can be taken. And this is without exception, where illegal activities are performed by either the employees or even the management. I believe in your organizations, we have a whistleblowers protection, where employees can report in confidence to the relevant authorities so that action can be taken. Employer rights. These are the rights that relate to the employers. And what are these rights? Right to manage operations. That means that they should design a system which enables employees to perform their work effectively. And this system includes giving directives, assigning duties, and supervising employees on a daily basis to ensure that they are doing the right things in the right way, at the right time, and at the right places. That means that they should have relevant procedures and processes that all employees must follow. Number two is the right to set work standards, where employers set reasonable performance expectations and ensure that employees perform accordingly. These performance expectations are contained in the performance contract, especially those in private public sector, and that employees are evaluated based on those standards or expectations, which include targets and KPIs. Thirdly is the right to protect the business, that employees have a right to protect their business from collapse or from infringement. And that includes safeguarding their trade secrets. That includes, especially in the manufacturing sector like drinks, there are chemical combinations, those are trade secrets. Confidential information, any information that relates to an organization should not be divulged to third parties, and employers have a right to demand that such confidential information be kept. In case this confidential information is given out to a third party, then the employer can start a disciplinary process. And lastly is intellectual property, where the copyrights must be respected so that there is no infringement. There is nobody that can give out these copyrights to other organizations or other individuals that will amount to sabotage. And this is a very serious offense under the Employment Act that amounts to gross misconduct. And the summary dismissal can be constituted. Right to enforce discipline, and again, I've talked about the disciplinary process, that if an employee is committing an offense or is engaged in a misconduct, he should engage in a legal process to ensure that employees desist from committing such an offense. Termination, an employer has a right to terminate an employee's contract according to Section 35, as long as it is lawful termination of a contract. And this termination may relate to redundancy or discipline or performance. Right to implement policies. Again, employer has a right to ensure that all policies are complied with. And it is from these policies that we develop SOPs, standard operating procedures, so that employees have no excuse of not following the policy requirements. So those are some of the rights of the employer in all the organizations, whether public or private. Obligations of the employer, just like the obligations of the employee we discussed earlier. One, provide written contract. Under Section 9 of the Employment Act, the employer is required to serve an employee with a written contract indicating the terms and the conditions of employment. Without this contract, then there is no relationship between the employer and the employee. And in case an employee goes to court, there is no contract. And that becomes a challenge when the employee has not issued a contract. Under the Employment Act, that the employer provides a written contract. Secondly, an employer is required to pay salaries and wages according to the contract. And the key word there is promptly and fully. Promptly means on time, that the payment should come at the right time, and it's usually at the end of the month. And fully means that the employer pays the employee what he or she is entitled to, including statutory deductions. So whatever remains is what the employee is paid fully. There should be no other deductions except the statutory deductions or any other deductions that the employee may be willing to be deducted. Thirdly is ensure health and safety environment. Under Section 6 of the Act, employers must maintain a safe and healthy work environment so that employees are protected from illnesses and accidents. This again goes a long way in ensuring that the working environment is socially and physically safe. Many of the mental health cases relate to employment relationship, which is unhealthy and unsafe. Unhealthy relationship not only relates to factors that may cause illnesses, but may also relate to relationships where the environment is toxic and that the social environment is not supportive of the employee's performance of work. Another one is to grant leave. We mentioned the various types of leave, that is annual leave, sick leave, maternity and paternity leave. In some organizations, there is an arrangement where an employee goes for leave for half a month, and then they resume work, and then again go for leave. Ideally, the Employment Act stipulates that an employee should go for at least 21 days uninterrupted leave. And my colleague Paul Bonyok will expand on this. Lastly is prevent discrimination. Under the Employment Act, employees should not be discriminated against when it comes to hiring or disciplinary or training or compensation. meaning that the employer should avoid any situations that may lead to discrimination, which may amount to unfairness. Before we move on, I want to invite questions and comments from any one of us based on what we have covered, and that is part two of topic 1, supporting statutes, enforcement and compliance, contractual integrity, breach and enforcement, employee rights and obligations, employer rights, and then employer obligations. So the floor is ours. Please go ahead and ask your question or make your comment. Thank you.
Andrew, my question is on enforcement and compliance, the first one, under employer obligations. Under employer obligations.
You are breaking. I can't hear you well. Go ahead.
I said on enforcement and compliance under employer obligations.
Yeah.
I wanted to understand these the records that we keep, especially the disciplinary records. Are there time limits? How long one can keep that record? And secondly, keeping the employee record of an employee like an employee file. If the employee has exited the organization, is there a period we should keep that file? Is there a guideline on how long we should keep the file? That is, and then on under alternative dispute resolutions, I wanted to know if you can guide us on the mediation process. Mediation process.
Okay, mediation.
On contractual integrity, under non-discrimination, sometimes we have unionized employees, and there are others who are not willing to join union. As it is said, the employee should be willing, but they belong to the same grade. So you find union through the CBA has probably negotiated 30 days of leave. The Employment Act provides 21. So the non-unionized employee is given 21. Is that considered as discrimination? Because they probably are doing the same job. They're in the same grade. One is getting 30 days of leave because the CBA negotiated it, and the other one gets only 21 because of that. And still under contractual integrity, I wanted to understand whether termination is synonymous to dismissal, because it's like any termination, a person must go through the fair hearing procedure, whether it is redundancy, poor health, reorganization, performance failure, all that. So I wanted that clarification. And then on employee rights, leave entitlements, I'm seeking a clarification on sick leave, because you said the first month full pay, the second month half pay, the third month no pay, then you begin the process of discharge or medical discharge, meaning the sick leave provision is 3 months. I just asking a clarification there.
Okay.
Thank you.
Thank you, Consulate. You talked about duration of the records that we keep.
Yes.
Related to either disciplinary or any other process. The law provides that you keep the records for at least 5 years or 7 years, depending on the sector, so that in case of a future need to refer to these documents, you are protected and that you don't struggle to get this. And this can be kept in your archives in case you don't have any immediate need for them. And the archives can be electronic or manual. But in an era like ours, please save it in an electronic system or a digital system where you can easily retrieve or refer to it in case a need arises. You talked about alternative dispute resolution, and you talked about mediation. The process of mediation. In this process, the employer and the employee have had their own process where they do not agree on certain issues, especially where there is a union that they have not agreed, and therefore they have agreed to disagree. The law provides for mediation where the two parties can invite a third party of their choice to come and listen to the issues and help them resolve their disputes or their disagreement. So there is an agreement between the two parties, and then the mediator is identified by both parties. And after that, the mediator comes on board to listen to them. And both parties present their views before the mediator. The mediator facilitates the discussions without interfering with them. The role of the mediator here is to guide the discussions from beginning to end. And then if there are facts or there are matters that are agreed upon, they are recorded as agreed. And those that are not agreed are scheduled for further discussion, either with the mediator or with the conciliator if need arises. And if all the matters have been agreed upon, that becomes a contract. And that contract is registered, either if it is through a union, it is with the Labor Relations Court, or kept within the organization if it was a mutual agreement. And those agreements become binding to the parties. And in case there is any need to go to a court, then any party is free to go to a court to seek redress. And after that, the decision of the court is final. So that is basically the process of mediation. You also mentioned something to do with unionizable organizations, where the union negotiates annual leave for 30 days, and for those on contract, 21 days. The law requires that an employer gives annual leave of at least 21 days, at least 21 working days. So many of us look at that as 30 days leave for those that are unionizable, because that is in their contract and that is in their CBA. But those that are not unionizable, it is not discriminatory because you have met the minimum requirements as per the law. Because they are not in a union, but if they wish to join a union, they are free, so that their days can be increased to 30. But because they have agreed, and this agreement is mutual, I think 21 days is sufficient. And then you asked another question on termination and dismissal. And your question is, are they the same or they are different? The answer is they are different. Termination refers to end of an employment contract. End of an employment contract. And it can end either voluntarily or involuntarily. Voluntary termination is initiated by the employee, and this is by way of a resignation. An employee has a right to resign at any time and gives notice of termination. The employer can also terminate the employment contract, and that is involuntary termination. And some of the basis for this involuntary termination is misconduct, and secondly, performance. Misconduct is where dismissal comes in, that an employee has been dismissed on the basis of misconduct. Or an employee can be dismissed on account of poor performance, where the employee has not been able to meet the performance standards as set in the contract. So termination is general, where an employment comes to an end, either voluntarily or involuntarily. And in case of a dismissal, there is a process that has been followed. And in this process, it could be a disciplinary process where an employee has committed an offense and therefore dismissed on account of indiscipline. And the contract can also be terminated on account of poor performance. And then lastly, you talked about the rights of the employees when it comes to leave entitlement. And your question was whether the leave can be a minimum of 3 months or a maximum of, rather a minimum of 1 month or a maximum of 3 months. An employee can be sick for a short time, say 4 days, 5 days, or 10 days. And according to your policy, an employee can be given sick leave up to a maximum of 4 days. But if the sickness or the injury as a result of an accident is prolonged, that means treatment takes longer, then the first 1 month, the employee is paid full pay. The following month, an employee is paid a half day. And then the last month, there is no pay. And after that, the employer starts an exit process for the employee. So the right is that an employee has a right to sick leave depending on the nature of the sickness or injury. If it is short, a maximum of 4 days, but prolonged, it could be 1 month, full pay. Next month have pay, and the other month, no pay. Consulate?
Yes, please.
I believe I've answered your question, and my colleague Paul can come in and then give his insights.
Thank you.
Thank you, Bwana Andrew. Thank you, Bwana Andrew. I just want to add a few things here and there. Just from where you left on sick leave, if the sickness is prolonged, then the law requires a letter from a registered medical practitioner indicating the extent of the sickness for purposes of consideration by the employer. Then on the other matter on collective bargaining agreement, where some people have more days than the others in terms of annual leave, you are right to say that those who are not in unions and have not joined so voluntarily, because a union is a voluntary organization, they will get their 21 days, the others will get their 30 days as per the CBA. However, there is what we call agency fees. If, for example, it was a matter of salary increment that has been negotiated by the union, that would mean if the employees were all in the same caliber, so that, because some of them may not be in the union, they are in the same caliber, but they have decided they are not joining the union, then the law requires those who are not in the union to pay to the union what is referred to as agency fees, because the union becomes their agent for that purpose. So that the salary increment will be for all the employees, regardless of whether they're in the union or not. But for this case, I heard that there were people who are employed on fixed term, who are not members of the union, and then there are other cadre of employees. So your position stands if they are in different cadres and employment contracts. But if all of them are under the same parameters of permanent and pensionable, for example, employment, then those who are not in the union must pay union fees, so agency fees to the union, so that they also enjoy the benefits negotiated by the union. And then the third issue was on mediation. I would like just to add that mediation is a voluntary exercise. The mediator is a facilitator. He doesn't dictate what is to be done. And the findings of the mediation is voluntary. Either members can accept it or they can reject it. If they reject it, the matter moves on. It is not binding on them. The fourth and last point was on records. And on records, it is governed by the Employment Act and the Data Protection Act, because the question being asked was, how long do we keep these records? The records may be in terms of letters, of notices, minutes, evidence, and of the proceedings and all that. What the law requires is this. If it is a minor offense, a minor disciplinary matter, then the records can be kept between 1 to 3 years. 1 to 3 years for minor misconduct. For major or serious misconduct, the law requires them to be kept for 5 to 6 years. 5 to 6 years maximum, not beyond. And that 6 years maximum is based on a law. There is a law called the Limitation of Actions Act, Cap 22, Chapter 22, which places the period within which rights of parties have to be implemented in a court of law. In this case, that act places 6 years as the maximum period within which you can assert your rights in a court of law on matters contract. Employment being a contract, the maximum is 6 years you are given as an employer or employee to assert your rights in a court of law. This is why the records go up to a maximum of 6 years. Whether it is minutes of the meetings, nomination letter, or evidence, any evidence given, you keep it. But as I said, for minor offenses, 1 to 3 years. For major offenses, 5 to 6 years maximum. Thank you.
Thank you, Paul. Consulate, I believe you are guided, and there's Maria on the line. Please, Maria, go ahead with your question or comment.
You spoke of uninterrupted minimum 25 days leaves. Is this when the employee has applied for all those days? Because sometimes the employee can decide to go for leave partly, maybe 10 days. And about leave, an employee could apply for leave, but the supervisor decides that they should not go because there's a lot of work. Is this allowed? Is this legal? Because one is applying for leave because they have a need at that time. Why should they be denied the leave?
Paul, go ahead.
Allow me to take on that. Now, first of all, annual leave is a fundamental right given by the Constitution. Sorry, by the Employment Act. Under the Act, every employee is entitled to at least 21 working days of annual leave. 21 working days. Ordinarily, it moves up to around 30 days because when counting the leave days, we don't include weekly rest days as well as any public holiday. So averagely it comes to that, about 30. So, and as we said earlier, the Employment Act provides the basic minimum. So the minimum here is 21 days. If the employer decides to give even 2 months annual leave, that is for the benefit of the employee, and it is a better term than what is contained in the Employment Act, which is acceptable. So again, on partial leave, the nature of the work the employee does or the organization undertakes may dictate that we cannot give employees full leave. For example, if you are working in the hospitality industry and it is during the festive season, you may have reached your position to be given annual leave. However, at times because of the workplace condition, the employer may require you to take partial leave so that there is continuity to take care of the objectives of the organization. In this case, what the law requires is that partial leave can only be given to an employee with the employee's consent. The employer cannot force it on the employee. So if the employee declines that I do not want to take partial leave, then the employer cannot force it on the employee. The employer will have to grant the entire leave. Thank you.
Thank you, Bob Paul. Maria?
Thank you. I'm guided.
Thank you. Consulate, I believe you are also guided.
I'm guided, but I want to ask something about that sick leave. Sick leave is not working days. It is consecutive days, right? And sometimes a public holiday will fall when somebody is on sick leave. Are they also compensated?
Thank you, Consulate. A sick leave is a sick leave. It means that a person cannot work for the period that he or she has been given, whether it is 1 day, 2 days, or 3 days. But in case of prolonged illness, like my colleague has said, the law requires that a medical practitioner gives his or her findings about the employer, about the employee, on the basis of which a termination on the basis of ill health can start. But going to your question about whether a public holiday is counted, yes, when somebody is sick and he recovers on a public holiday, yes, they can still come back to work.
Mr. Odali?
Yes.
May I chip in?
Yes, please do.
If I got that question well, she requested to know whether when one is on sick leave and it is on a public holiday, or a public holiday falls in between, say, or rather say a weekend falls in between, whether those still counts as sick days. Or do we say, for example, because this person has a 3-day sick off on a Thursday, and Friday is a public holiday, then they will not come back on Tuesday or some other day, because they this employee argues that, you know, I had 3 days sick off, but Friday was a public holiday. So can I continue resting in bed?
I chip there.
Yeah, my answer to this question, and I hope it will be helpful. Sick off is not meant for enjoyment. The sick off is not meant for, it's not a privilege. Sick off takes the literal days. You've been given or you've been granted a 3-day sick off on a Thursday. So your 3-day sick off runs from Thursday, Friday, Saturday. See, you've been granted the 3-day sick off, and this is on a Wednesday. And then Thursday happens to be a public holiday. So your 3-day sick off counts on Thursday. Wait a minute. You've been granted 3-day sick off starting Wednesday. Then Thursday happens to be a public holiday. So your 3-day sick off would start on Wednesday, one day, Thursday the second day, Friday the third day. Notwithstanding that Thursday was a public holiday. These were 3 days meant for recovery, whether it was on a weekend or a public holiday. Thank you very much.
Thank you. It's clear. Thank you.
Thank you, Dan. Thank you very much. Somebody raised a hand. If there's nobody with a question or a comment to make, I would request that we move.
And Molim, I could add something on top.
Yes, please.
Sick off and the holidays are very interesting topics. And very soon, we should have a webinar primarily to deal with this. I remember a few years back, an employee came to me and she had requested to go on, she had requested to take her days. She had several pending leave days. Then I guess this person was answerable to the CEO at that point, or to the boss. And this boss happened also to be my boss, but I was the HR in charge. So when she was denied to take her days, because it happened that there was a very important activity to be undertaken, and her presence was needed, she didn't take it kindly. And you know, you can never know what is in the heart of an employee. But trust me, she didn't show up for the exact period of days she had requested to be away. She didn't show up to work. So the boss was there fuming and throwing tantrums, right, left, and center, asking, what are you doing, HR, about this? And you see now, remember this employee had several days pending that she would have, we could have resolved that issue if we would have, had we granted her leave days, her leave request. But now because we denied her this, or she was denied that, she decided to go and see her medical practitioner, her personal doctor, who granted a 14-day sick off. Yeah? And then we had a policy that, and we should also, again, as HR professionals, look at what our policy is saying. This policy said one can only be granted leave on medical grounds from a licensed medical practitioner. And this was a brilliant employee. Wow, she had read that part and internalized it perfectly. So she sought medical leave or the sick off from a licensed medical practitioner. I remember there is this issue of doctor-patient privacy, but she had a sick off by the time she was resuming back to work, smiling actually. And well, you could tell she had not been unwell at all. Okay, but then 14 days was a long time for somebody to have fully recovered and could smile. So then the boss said, okay, no, I don't trust that sick off. You need to go and check whether this sick off is genuine. And being a good and supportive HR, and you know, HR for a very long time has been misused by many, that you are always supportive. Sometimes it's supportive. I don't want to say, let me not even use that word because this is being recorded. Now, so I took off to Kasarani, to where this sick of had been stamped. So I sought the audience with the doctor. So I had a very simple question, whether this sick of came from the hospital. So the doctor said, yeah, this sick of came from this hospital, and that is my signature. And as if he could read my mind, he said, he added, and that is my license up there. Now, what would you have said as a HR? You see, he has not even waited for you to ask whether he's a licensed medical doctor. He's already telling you, that is my signature, that is this time, okay. That SICOF was issued from here, and I'm a licensed medical practitioner. So I thanked him profusely. I decided to visit sometime for consultation. I never went back, of course. But you could have seen my boss trying to find ways. And a lot of bosses waste a lot of time trying to find ways or about fixing employees, which is unfortunate. So he was there. I feel he, up to now, I guess he's still simmering, but the employee went scot-free on that one. So sick off, leave days, sometimes it is always necessary, and if possible, allow employees to take their leave as granted for by the law. If you don't, the employee will still take their annual leave. Sitaki kutumia upende usipende, but they will still do it. There are so many ways they are able to circumvent the law, but they will still take their 30 days in the course of the year. Thank you.
Thank you very much, Dan. Consulate, I believe you are well guided. And with your permission, now we step into the next topic, and that is disciplinary and performance compliance. Sorry. As I indicated in my introduction, disciplinary and procedures are very key in the employment relationship, and especially when it comes to the rule of law. Fairness and justice must not only be seen, but actually be implemented according to the law. Many of the cases that are taken to our labor relations courts revolve around disciplinary matters where an employee's contract is unfairly dismissed. And this is where many organizations lose cases because of either lack of effective procedural fairness or substantive justification. And in some cases, performance is treated as an indiscipline, which is not right, because disciplinary is a process which involves investigation of an offense. But performance is not any investigation, but based on performance records from performance appraisals, and the intention of performance reviews is to ensure that the employee has improved their performance, as opposed to disciplinary process, which may lead to a termination of a contract and requires investigations. To start with, let us talk about misconduct versus poor performance. As we have indicated in the concept of misconduct, this is a willful breach of rules, a and the regulations governing the employment relationship, or unacceptable behavior by the employee. Unacceptable means that they have violated the codes of conduct, the policies, rules, and regulations, as well as the law. So misconduct is willful violation of the rules and the law. While performance management is inability to meet targets or standards set by the employer, inability. And it may not be willful unless there is an element of sabotage or insubordination. And a person may not be able to meet targets because of lack of training, lack of tools, lack of motivation, and a poor working environment and conditions. What's the nature of fault, especially when it comes to misconduct? There is deliberate wrongdoing. Deliberate is the willful breach, where a person decides to commit an offense against the provisions of the law. And in some cases, it could be ignorance. But as my good friend Paul would argue, ignorance is no defense. There are rules, there are laws, you are expected to read them, understand them, and apply them. On the part of poor performance, it's about inability or incapacity arising from skill gaps or lack of tools. And therefore, it may not be termed as misconduct. What's the approach to disciplinary process? One, it attracts a form of punishment that if an employee commits an offense, depending on the nature of the offense, if it's a minor misconduct, then it can lead to a warning or a suspension or a surcharge in case somebody has broken public, rather private organizational property. On the other hand, performance requires support that the employee may not be able to achieve the targets because of lack of tools, lack of equipment, and lack of skills. And the intention of performance reviews is to improve performance and put in place improvement plans. For example, PIP is an improvement plan where an employee should be supported so that they can reach the required standards as agreed. Evidence requirements in both misconduct and performance. In misconduct, there is need for investigation to establish the nature of the offense, the parties involved, and any violations that were made by the suspected employee. So the key word there is investigations. On the part of performance, the evidence required is appraisals, which we conduct either quarterly, biannually, or annually. And again, this depends on your policy. The results of this appraisal will show whether the employee is performing or not. Those who are not performing, then they are supported by providing them either skills and knowledge, tools to perform, or creating an environment where they can perform. The other aspect is metrics. These are measurements of performance, especially KPIs use metrics, which are mainly quantitative, like the number of objectives that have been achieved in the performance period or appraisal period, the revenues generated. Number 3, the time taken to perform tasks. And then number 4, the amount of money used to perform that tasks. So metrics can be used to measure the level of productivity of an organization or even an individual employee. And then lastly, corrective measures. In the case of misconduct, there are sanctions in the form of either suspension, demotion, fines, which are usually by the courts, and then in case employees have committed an offense, there could be as well as dismissal. Employees can be dismissed on account of misconduct. In the case of poor performance, the remedies are training, effective supervision, and the provision of necessary resources. So those are the key differences between misconduct and poor performance. What are the forms or types of misconduct that employees may be engaged in? The first one there is gross misconduct, where there is a serious violation of the policy, rules, regulations, and the law. I have given examples of these violations, which include using abusive language, 2, threatening an employee or a supervisor, or 3, being disrespectful. And that disrespect amounts to insubordination. So this insubordination can attract a penalty, and usually it is summary dismissal if an employee is found guilty. Absenteeism without lawful excuse means that an employee does not inform the relevant authorities that they will be away from work and giving a reason for being away. So if somebody does not give or communicate to the officers about their absence, that amounts to a gross misconduct. But allow me to say that being absent for one day may not be gross misconduct, even if the law does not provide specific time for absenteeism. The Employment Act does not provide the specific days an employee can be away from work without authority. But that also gives us an opportunity to develop policies around this aspect of absenteeism. The law only says that there is reasonable time given that an employee is absent from work. So one day may not be reasonable, 2 days may, 3 days. But most policies that I have looked at talk about 2 days, 3 days. So that is considered absenteeism. And if a person is absent for many, many days, that becomes a gross misconduct and the disciplinary process may start. But again, the process must be fair. Even if an employee is absent for a month, there are certain background checks that an employer is supposed to look at, including whether the employee is well, is not sick, or nothing has happened to them. And that requires that you use the last contact or address that the employee used so that you can get with their next of kin or any other person known to them. Intoxication is another type of gross misconduct where you are incapacitated from performing your duties. So if you can't perform your duties due to intoxication, that is gross misconduct. In some cases, organizations take these employees for counseling, especially in public sector. They do counseling so that they can rehabilitate the employees. And in some cases, they take the addict to a rehabilitation center to a maximum of 2 times. Then willful refusal to obey lawful orders, which are reasonable, is another type of misconduct. Refusal to obey lawful orders. That is gross misconduct. And lastly, gross negligence of duties, which you are supposed to do. If you neglect your duties and you are supposed to do that, that amounts to gross misconduct. Theft, that is stealing company property or taking company property without permission. Even if it's a small thing like a pen, that is theft. Fraud, that is gaining financial gains through false pretense, gross misconduct, or violence. Violence here means fighting, and in some cases causing physical harm. All these come under gross misconduct, and a disciplinary process should start. And the due process must be followed as provided for under the Employment Act. Secondly is the minor misconduct, which are less severe violations, such as being late. You can be late once or twice, but continued or continuous lateness might amount to gross misconduct, and disciplinary action can start. Improper dress code, a warning can be made. Every organization has its own dress code, so employees are expected to comply. And if an employee does not, it might lead to a warning or even a suspension, as the case might be. Unauthorized breaks, that means people leaving early before time. That is also a minor misconduct. An employee can be warned. And lastly, failure to follow a procedure. However, let me mention that if a person willfully fails to follow a procedure, which leads to a large amount of loss, financial loss, or a collapse of the business, again, that will amount to negligence. And again, care should be taken that this negligence might cause a minor infraction, but if it's a major one, it becomes negligence. Handling misconduct. How do we handle misconduct, which basically falls under disciplinary procedure? And this is what Marie asked about the process of misconduct. The key requirement in handling misconduct is investigation, that the employer must investigate the employee based on the accusations and gather evidence before taking any disciplinary action. Secondly, there is a disciplinary process. If there is evidence that an employee has committed an offense, then a disciplinary process will commence, where a notice to show cause is issued, a response is received, and a disciplinary committee is constituted in case the response does not satisfy the employer. And from there, a disciplinary action is taken in the form of sanctions, which includes warning, suspension, or dismissal. And this should come from the disciplinary committee and not an individual. But in the case of warnings, if an employee has committed a minor offense, a HR manager can warn that person in writing or orally. And again, let me address myself to the types of warning. There is formal, informal oral warning, and then formal oral warning. and then written warning. The formal oral warning must be recorded in the occurrence book or in your records so that it forms part of the evidence that the employee has been a persistent violator of an offense which is minor. Gross misconduct, how do we handle that? It's a serious offense, and that calls for summary dismissal. And again, due process must be followed as provided by the Employment Act. Consistency principle means that the laws must be applied to all employees, irrespective of their position. There should be no discrimination. Otherwise, an employee can sue for unfair dismissal because of this inconsistency. That if an employee has come late once, nothing happens to him or her. But when you report late, a disciplinary action is taken. That is unfair and that is inconsistent. And lastly is right to representation. My colleague mentioned in the case of misconduct, an employee has a right to be represented by a fellow employee or a member of a union, and in rare cases, a legal representative, and this is a lawyer. The lawyer representation does not include going into the fundamentals of the case, but the lawyer is there to advise and not to argue the case for the employee. And I believe my colleague Paul will address this in a little while. Then how do we manage poor performance? One, we start with assessment, where we do an appraisal of the employee's performance against the set objectives and targets. If there are indications of performance gaps, then the employee is put on a PIP, that is performance improvement plan, which can last between 3 months to 6 months, and in some cases to 1 year, depending on the policy. In private sector, probably because of the need to perform and compete, the PIP may not last more than 6 months. But again, according to the law, there must be reasonable time given to the employee to improve. I believe 3 months is reasonable, and if the employee is supported, they should reach their performance targets. Another way of handling performance is training. Provide the employees with the training, resources, and supervision so that they are well equipped to improve their performance. Without this support, the employment relations court will always award the employee because of unfair termination. Why? Because the employee was not supported in the period of performance improvement. And then review meetings. Regular reviews are required, and these are given in our policies. It could be quarterly, biannually, or annually. Through these reviews, performance gaps are identified, progress is monitored, and employees are given continuous feedback. In progressive organizations, you don't have to wait for 3 months or 6 months. Reviews are continuous, which means that it's a daily thing, especially for organizations that have adopted dashboards. These are digital tools where performance results are posted on a daily basis, and therefore gaps can be identified through these dashboards. And employees are given opportunities to improve given the resources of the organization. I've talked about reasonable time. Employees should be given enough time to improve their performance. Improvement of performance is not like instant coffee. It requires time. 3 months, 6 months, or 1 year could be adequate time for a person to improve. And then what is the threshold for terminating contract on account of poor performance is failure to improve performance, that the employer has tried their best to provide all the support and the employee has not improved. When it comes to that, then termination may be instituted. But again, an employee should be given an opportunity to defend themselves so that there is fairness and justice. Otherwise, if there is no opportunity to defend themselves, and again, that becomes unfair dismissal. There is Section 4 of the Employment Act, which relates to procedural fairness in termination. And there are specific steps that are followed when a disciplinary process is being instituted against an offending employee. And this is particularly Section 41 of the Employment Act. And this section explains the procedures of fairness that are required before an employment contract is terminated. Secondly, the element of notification. The employee must be informed of the allegations against them promptly. That if an employee is notified of an offense 3 months or 4 months down the line, that may amount to witch hunt, and that can be unfair. So promptly, again, will be captured in your policies. Is it 1 day, 2 days, or 3 days? But there should be adequate notice. It could be 24 hours or 72 hours, depending on the nature of the offense. The right to hearing is another essential part captured under Section 41, that an employee has a right to be heard, irrespective of the offense they are alleged to have committed. And that requires that a disciplinary committee is constituted and an employee is requested to attend the disciplinary hearing so that they can defend themselves and respond accordingly. If need be, they can also bring a representative, and that talks to a representation on point 4. Employees can be represented by fellow employees or a union or a legal officer or a lawyer. Consideration process, that the employer must consider the explanations given, that probably the reason for committing this offense arose from a condition that they could not avoid. For example, an employee's child could be sick or injured, and in the process, they failed to notify the employer because of the emergency. That explanation is adequate, and therefore disciplinary action should not be taken against the employee for being absent. This makes it fair and justified because there is reasonable ground to believe that the employee was responding to an emergency, or the employee himself or herself was unwell and had to visit a doctor or a hospital. So this is a consideration that must be taken by the employer in order to promote fairness. And lastly, communication. When a disciplinary process has been undertaken, or even before, the employee must be informed of the offense. And after, the employee must be informed of the verdict of the disciplinary committee. And this must be done within reasonable time. And lastly, the employee should be given a right to appeal to higher authority, because the disciplinary committee could have overlooked certain matters. And in that case, an employee can approach a higher authority to have his or her case addressed. What are the steps according to section 41, that should be taken from beginning to an end. My colleague, Paul Bonyo, talked about this, and I'm sure you will emphasize this as we close. Notification, that is a notice to show cause why disciplinary action cannot be taken against the employee. And a notice can be 24 hours, 7 days. And this should be adequate enough for an employee to respond. Secondly, preparation period. An employee should be given adequate period. Even if it requires an employer to suspend the employee while investigations are being conducted, the employee should be given adequate time to prepare, especially during that suspension period. Then a disciplinary hearing by the disciplinary committee should be conducted. And again, this must be compliant with the law so that an employee can present their defense in the best way they know how and respond to allegations. This is how we promote a democratic organization as well as fair and just decisions. Without giving an employee a chance to defend themselves, that will amount to unfair termination. And my colleague will talk about case law related to ELRC, where an employee was terminated without being given an opportunity to defend themselves. And then consideration, the disciplinary committee evaluates the evidence given by all parties, weighs them to determine their veracity, and then makes a disciplinary decision. And this disciplinary decision could be suspension, surcharge, or dismissal, depending on the evidence given. And this disciplinary action must be objective. There should be no biasness. Otherwise, biasness, if detected, can lead to unfair dismissal. And then, as I have indicated in the previous slide, decision communication, that the disciplinary committee through the chair should communicate in writing to the employee, stating the reasons for the decisions and what is required by the employee to do. If it's a suspension, they will state the reason, the period of suspension, and the expected behavior of the employee during suspension. And then lastly, an appeal, where an employee is allowed to appeal, and this is subject to your policy, and it's a requirement of the law. Usually you are given 14 days to appeal the decision so that fairness can be seen to be undertaken. What are the common mistakes that employers make when conducting disciplinary procedure? One, not giving the suspected employee a hearing. That process is very important because if you skip that, the Employment Act is very clear. It will lead to unlawful dismissal and employee can be awarded. Inadequate notice, as I indicated and my colleague mentioned it, there should be reasonable time of notice to show cause, either 24 hours or 48 hours or 72 hours. Beyond there, I think that will be a very long time and anything might have happened in between. Bias risk, I've just mentioned that if there is discrimination or a committee is impartial when conducting this process, then again, that is a common mistake that they can make. Failure to record all the processes in the organization. And again, that can become a weakness on the part of the employer, and the case can easily be dismissed when it finds its way to court. Representation, and again, Section 41 is clear on that. An employee has a right to be represented by a fellow employee or a trade union, or in some rare cases, a legal expert to guide the employee or to advise, but not to argue the case. And then lastly, rushing the decision, that an employee is given 7 hours to respond, 1 day hearing, and within that 1 day, a decision has been made, which means that an employee has not been given adequate notice. 2, sufficient time to prepare. 3, representation. And 4, consideration of evidence. So a disciplinary action that is comprehensive enough should not take 1 day. It should take reasonable time so that the decisions are not interpreted to be rushed. What are the documents required for you to ensure a fair and just process? There are many which my colleague mentioned. It will be letters of appointment, notices of response to an accusation, or it could be suspension and others. So what is the purpose of this documentation? It is to ensure accurate records. Accurate records are those that are factual, based on what happened and supported by documents. 2, there are no inaccuracies or inconsistencies. And in this way, these records can help to support compliance and dispute resolution. Consistency and accuracy, this record should be uniform throughout. If it's an employment contract for the same level, it should be the same. The record should be accurate and timely. That if it is a notice to show cause, should be timely, not coming too late, and that can be an unfair treatment of the employee. And again, as a legal requirement, documents are required for compliance, that in the Employment Act and other acts which we have mentioned, like WIBA, Labor Relations Act, they require documentation. Otherwise, you cannot argue your case out in a court of law without documents, because that will be hearsay. Last, and then the element of confidentiality, that much as the disciplinary process is internal, the process should be confidential, that the findings of the committee should not be divulged to the employees who don't need that information. So information should be passed on a need basis, so that data protection is ensured. Otherwise, an employer can find themselves in court because of data protection violations. Audit trails, and this is what we insist on when we conduct HR audits. Audit the nature of your documents. Are they clear? Are they accurate? Are they relevant? That without this, then there is a possibility that the organization might lose a case which could have been won very easily. And then lastly is the retention and storage. My colleague mentioned that if it's a minor offense, 1 to 3 years. If it's a major offense, it is 5 to 6 years. And this is a legal requirement in order to protect ourselves from lawsuits. What is the purpose of documentation before we go to the last part? One is legal compliance, as I've mentioned, that the law requires that you keep documents, and safely so. Evidence preservation, documents help us to preserve evidence, and they should be stored in a safe place. Otherwise, data integrity is key, Because if somebody else who is not authorized accesses this document, it can be a big risk. For example, there is a case where an employee altered the decision of a disciplinary committee, and when it got to the HR to disperse the letter, the verdict was different from the original. And when the HR manager looked at the letter, she doubted that this is not what was agreed on. And upon checking, the HR manager found that data had been changed. And that is a violation, which means that there is a gap somewhere in terms of data protection. Consistency, again, uniform handling of all documents and evidence that is presented. Transparency, we should give clear evidence on what is on the accusations, whether it is disciplinary or performance related, so that we hold people to account in case there is a breach of the integrity of the documents. And again, risk mitigation, that in the presence of proper documentation, then there will be no adverse judgments or penalties or compensations by the employees. In that case, we are protected, and this is part of risk management in HR, ensuring that all documents are kept properly and that they are accurate, they are relevant to the cases. Lastly is audit. Audit is an assessment or evaluation of all the records to assess their relevance, their accuracy, and compliance levels. And this is very important when it comes to disciplinary and performance management. What are the key documents? My brother Paul talked about it: show cause letters, invitation letters, hearing minute, that is the minutes taken during this hearings, warning letters, especially for minor offenses, performance improvement plans, what are the records related to target timelines and the support, and outcome letters, which are the decisions taken by the disciplinary committee or any appeals committee, including performance appeals committee. The best practices in documentation, which I've alluded to, is accuracy. The records must be factual and clear. Timeliness, not too early, not too late to preempt or to unjustly accuse a person after a long time. Confidentiality, protect any confidential information. Consistency and retention. On the retention, I repeat, for minor offenses is 1 to 3 years, for major offenses 5 to 6. And on that note, we come to the third part of our discussion this morning. And again, I will invite questions or comments from all of us so that I give an opportunity to my colleague to wind up with case laws. Any comment, question that you may have, please go ahead. Anybody with a question or a comment?
Good morning.
Morning to you.
I'm just wondering, in case of disciplinary action, an employee has been accused of gross misconduct, and maybe we don't have enough evidence to pin him down. And he has also denied everything that has been presented. What would be the best solution to such a scenario? Yeah.
Okay. Thank you. As my colleague and I mentioned earlier, gross misconduct is a major offense which can cause damage to the organization or even possible closure. That gross violation requires immediate action and that is why summary dismissal kicks in. So gross misconduct falls under gross misconduct under the Employment Act, that is committing a major offense. You have indicated that during this process, there are some facts that are not available to you as the employer, and the employee has denied all the allegations. Two things before I give an opportunity to Paul to respond. Number one, for you to accuse somebody of gross misconduct, you must gather all the evidence that you require, all the evidence. And I can take you back to one of the requirements which I mentioned. One is investigation or yes, investigation. You can see my slide. You must investigate the offense thoroughly before you accuse a person. That is a requirement. Investigation so that you can have a watertight case so that you don't accuse the employee falsely. If you conduct this without facts, the employee can even sue you for violation of his rights or false accusation. And this can go to court. And the employer can really suffer the consequences. He can suffer reputational damage. For example, theft. You have accused somebody of theft. And in the process, you find that there was no theft, you don't have evidence. That becomes false accusation. And that employee can easily go to court and accuse you for damage of his or her reputation. So investigation is very key. Secondly, if you don't have evidence and the employee has denied having committed an offense, it is better to drop the case. That will be mission aborted and inform the employee that there was no enough evidence against him, and therefore the case is dismissed. I now would wish to invite my colleague Paul to respond to your question and also take over for the rest of the balance of the time, and that is case law. Paul?
I also have questions after he has responded to hers.
Okay, fine. Thank you.
Thank you, Bwana Andrew. Allow me just to respond to that matter of no evidence. As you intimated, the employer must conduct investigations that is credible, because the accused here is the employee. And the burden of proof of the allegations lies with the employer and not the employee. That is based on the principle that one who alleges must prove. No evidence, no case. And if there is no case, the employee is innocent. So it moves nowhere.
Yeah, I think that is noted. Yeah, thank you.
Okay. Under handling misconduct, investigations, I'm seeking a clarification. Who should carry out this investigation? Is it the HR? Is it the supervisor? Or any member of the disciplinary committee? And then under notification requirement, sometimes you're giving the employee a notice and they refuse or dodge to receive or allege suddenly they're fallen sick, their phone is off. What should we do in that situation? And still under that clause, there is communicating the outcome. Who should communicate this outcome? The CEO, the HR? Then in the step-by-step process, disciplinary hearing, who is the best to chair that disciplinary hearing. Under your comments for pitfalls, looking at rushed decisions, you emphasize.
Thank you. Consulate?
Yes, please.
You are saying something, go on.
I was saying comments on pitfalls,
Or pitfalls.
Under rushed decisions.
Mm-hmm.
You did emphasize do not take a decision in one day. So I was wondering, sometimes the employee is caught red-handed, theft in the morning. And, maybe the person is even pleading, forgive me, forgive me. If by the end of the day you're finished with that hearing, is there really an offense? Because the person is caught red-handed with the theft. I think that is the last one.
Okay, I think the last one is fairly easy, and I believe Paul will address that. Paul?
Thank you, Bon Andrew. On pitfalls, on rushed decisions, the problem will be that the employee who has been alleged to have misconducted him or herself appears before a disciplinary committee. The wrong is read to that person. The person is given an opportunity to defend. The person admits the wrong as stated by the participant. And we want to make a decision on the very day. The law requires that after the whole process, even if admission is there, the disciplinary committee must retreat on their own and make a decision. It will not, we normally say justice must not only be done, must be seen to be done. That is the basis upon which we are saying if it is a one-day disciplinary committee process, it might not be seen to have been done justice. So you can actually retreat, make your own statements, sit the next day, make a ruling.
Okay, thanks.
That is the fairness we are talking about.
Yeah.
On who chairs the disciplinary committee, ordinarily, it must be a person who is neutral. The law requires the committee to have neutral and impartial persons. But it should be somebody who's in a senior position. Remember, HR appears in the committee, disciplinary committee, only to give advice. So the HR cannot chair that committee because the HR itself is not neutral. Now, on communication of the outcome, this outcome is normally given to the appointing authority. Who appointed this committee? Who gave the committee the terms of reference? That decision will be taken to that person who appointed the committee, and it is that person to communicate the matter to the employee. You raised something on notification. How do we notify somebody who is escaping notification? Currently, it is very easy. If you cannot find the person physically, you send it through the email or through WhatsApp. It is legally recommended now, even for court proceedings. So that will be sufficient. And you also mentioned something on handling of investigations. Investigations is carried out ordinarily by HR. You can commit the supervisor to conduct the investigation, or if the matter is complex, you can even call for a specialized person, because the purpose of investigation is to have cogent evidence indicting this employee on the wrong alleged to have been committed. So you must do thorough investigation, even if it means calling an independent specialist outside there to help your case. Thank you.
Thank you.
Thank you, Consulate. And thank you, everybody, for asking the questions. And Mr. Bonyo, if you are ready, I will stop sharing and you share your presentation, if that's okay with you.
That's okay. Now, are we together? Are you getting me?
Yes.
Yes, we are.
Now, are we sharing the slides on the screen?
Yes, we can see your slides.
Okay. Now, we are talking about landmark rulings, but before that, allow me to say this. There are other tasks that my colleague mentioned that I would probably touch on them, but I would like to touch on them probably after finishing this part. It was touching on ILO conventions, that was number one. I wanted to add something on the Labor Relations Act. Then I also wanted to share something on statutory deductions, as he mentioned earlier. Then after that, I wanted to look at something on the right to representation. He also requested something on that. And a small thing on PIP. Then the last one will be on steps under Section 41 of the Employment Act. But as at now, we are talking about landmark rulings. Landmark rulings are case laws. Case laws sometimes are referred to as precedents. These are judgments of superior courts of record that are important for purposes of guiding the public, including HR professionals in employment relations. In this respect, case laws are important, and every HR professional must have the knowledge of the same, because they offer practical guidance on work employer-employee relations. Why? Because cases that come live before the court and decisions made upon them are real cases that arise from employer-employee relations practically at work. So they help the workplace on determining governance standards. They also determine matters of discipline, how they're supposed to be handled in terms of employer-employee relations in a lawful manner. They also help HR professionals to identify mistakes that are commonly made so that you can be able to rectify those mistakes in advance. They also act as a benchmark. You can rely on them, benchmark on them, and actually have policies that are in conformity with practices in courts. Case laws also prevent disputes. If you know this is the likelihood of a ruling by a court of law, you are good to go to actually put in place or implement preventive measures. Those preventive measures will actually curtail disputes and deal with matters of resolution in advance. We also deal with them for purposes of dealing with financial risk mitigation. Disputes are very expensive in terms of hiring lawyers, presenting them in case, filing case, there's case fees, and every other thing. You need to mitigate that. And you can only do that if you look at case laws and know in advance what the ruling is likely to be. In fact, it can even help you settle matters out of court so that you persuade the employee, you settle your matters out of court before they go to court itself. So much for that. Now, I have given out 4 real cases that have been decided by the Employment and Labor Relations Court, because that is where trade disputes between employers and employees go. One such case is the case of Juma versus Telecom Kenya Limited. This was a case based on poor performance. Remember, my colleague, Bwana Andrew, talked about poor performance and the procedure required to obtain lawful termination based on poor performance. This employee was actually dismissed. He was given notice through email terminating his employment on the basis of poor performance in the evening on a working day. Then the next day, the person was dismissed. And Juma was dismissed, and there was no warning given to him. Remember, only an email was given to him indicating that his performance was wanting, but there was no notice given to him. He was not even given a hearing and no PIP process. He was not satisfied with that kind of conduct. He went to court. And having looked at the evidence presented by Juma, the court made a ruling in favor of Juma. The court stated very clearly that Section 41 that we were talking about on notification and hearing was not complied with. Remember that section requires, it is called procedural requirement. It's a procedural notice that you must give notice, allow the employee to respond, allow the employee to appear before the disciplinary committee, blah, blah, representation by a colleague, advocate, or union representative. That was not done. So that section was violated. Together with that, Section 43, which deals with substantive reason, was also violated. This Section 43 requires that, one, there must be a valid reason for the termination. And even if the valid reason is there, requirement number 2, that reason must exist and proved. In the case of Juma, there was an allegation of poor performance. Was it proved? No. Only an email was sent to him. Number 2, did it exist? Was there poor performance? In the eyes of the court, there was none. And because of that, the court indicated that Section 43 requiring existence of a reason and the validity of that reason was not complied with. Together with that, the court said that in overall, because Section 43 of notification and hearing was not complied with, and there was no existence of a reason and proof of that reason, therefore it means Section 45 of the Employment Act comes into play. Section 45 talks about unfair and unlawful termination. Having failed in Section 41 and 43, Juma's termination was declared to be unfair termination under the Employment Act. In this case, if I may add, Juma was awarded compensation equivalent to 10 months of his salary, and he was reinstated. Why did the employer lose this case? As a HR, what do you need to learn here? That poor performance without warning, without hearing, and without a PIP process is a likelihood, or the likelihood of outcome in a court of law is that the person or the employee will win, and you will bring financial, reputational burden to the employer. So as a HR professional, it is important you take note of this, that before you dismiss an employee on poor performance, meet the requirements that we had discussed earlier and as indicated by Andrew. Please give warning, give show cause notice, allow the employee to respond. If the response is not sufficient, call the employee for a hearing, allow the employee to be accompanied by an advocate, a colleague, or a union official, and up to the end, then and only then, when you have evidence, you have the minutes of the proceedings as evidence also, then you know you are now covered. This case goes to indicate very clearly that matters of procedure are not cosmetic. That procedure under Section 41 is mandatory. It is not cosmetic. And under Section 43 of the Employment Act, again, you must prove that the wrong actually was existing, and you have the evidence of it in terms of proof. Otherwise, it will amount to unfair or unlawful termination under Section 45. So three key sections that you must take care of as a HR professional, very important. Section 41 on fair procedure. Section 43 on valid reason and existence of that reason. And Section 45, where we are now dealing with fair termination. And remember, Section 41 and 43 are two Siamese twins. They are inseparable. If Section 41 fails, even if you comply with Section 43, the entire case fails. If Section 43 is complied with and Section 41 is not complied with, the entire case fails. So you must comply with the two sections for you to be fair in all respects. And even if the employee goes to court, there will be no case. That is what you need to take care of under case 1. I want to go to case 2, then I will allow you to ask questions. Case number 2 is the case of Muga versus CCI Kenya Limited. It's a case of 2025. Now, this particular case is very interesting. It's a very interesting case because Muga was employed as Muga was employed. This is a call center. CCI Kenya Limited is a call center dealing with matters of customer experience operations. Muga is a lady who was employed here on probation. So she was working under probationary contract. And you know, probationary contract, first of all, it's supposed to run for 6 months, then another 6 months. It cannot go beyond 12 months. So she was employed on probation for 3 months, first 3 months. Then what happened is that this lady had her employment terminated without following due process. Again, no procedure was followed. The argument of the employer was that an employee on probation has no fundamental rights under the Employment Act, and therefore their termination could be done at will. This was the case before the Employment and Labor Relations Court. Unknown to the employer, the procedure required under Section 41 of the Employment Act, Section 43, equally applies to employees on probation. So HR professionals and participants here, even if the employee is on probation and not permanent and pensionable, or even on a fixed term contract, this procedure is mandatory. Remember, Section 41 and 43 applies to matters misconduct, matters poor performance, and matters incapacity. These 3 matters are subject to Section 41 and 43, regardless of whether the employee is a permanent and pensionable employee or a probational contract employee. So in this case, was the termination of the employee on probation right? This is what the court said, that this termination was irregular, and therefore compensation was awarded. The court made an observation that probation is actually not a free pass. And that basic fairness under Section 41 and 43 are key and must apply to employees on probation. Therefore, the employer lost. So as HR professionals, please take care of your employees, whether permanent or pensionable or on probation, by following the due process under Section 41 and 43. I would like to pose any questions within the two cases before we move to the next two, because I have 4 of them. Any question or questions, if you are getting me? I would presume silence means there is no question for the time being. I want to move to the next case 3. Case 3 is Onomondi and 9 others versus Brava Food Industries Limited. It's a case of 2025 before Employment and Labor Relations Court. Now, Omondi here and 9 others were employees of Brava Food Limited. They were employed as sales representatives. And one of them was actually a sales manager. Again, it is a case of poor performance. There were 2 issues here. One was on poor performance. The other one was on unequal pay. Remember, my colleague Andrew talked about equal pay for equal work. And that is a constitutional requirement under Article 41, under fair labor practices, as well as under Section 35 of the Employment Act. In this respect, Omondi and 9 others had their employment terminated, and the employer did not give them, there was no performance appraisal, there was no hearing conducted. Number 2, on unequal pay. There are 2 employees who are paid 70,000 shillings for work they were doing. But there is 1 employee doing the same work who was being paid 109,000 shillings. Remember, the law talks about equal pay for equal work. 2 employees performing the same category of work were being paid 70,000 each. There is 1 employee doing the same job and is being paid 109,000 shillings. In this respect, we are looking at whether the first of all the termination was fair. In this matter, the court observed that this termination lacked both procedural and substantive fairness. Remember, procedural fairness is under Section 41, dealing with the steps before termination takes place. Substantive fairness is under Section 43, where we divided it into 2. The reason must be valid, the reason must exist. So that, for example, if it is absenteeism, was there absenteeism? If you look at the logins, did the employee log in? If no, then there is absenteeism. What is the reason for that absenteeism must also be taken care of before we even go to the procedure. So, in this case, as I stated, the court said that this termination lacked procedural and substantive fairness. Having said that, it means Section 41 on procedural fairness, Section 43 on substantive justification, and Section 45 on fair termination was not complied with by the employer. The court gave a ruling and said that this was unfair and unlawful termination, and the employee were given reinstatement orders. Number two, for the unequal pay, the court stated very clearly that the employment requires equal pay for equal work, which did not exist in this matter. And therefore, the employees who are paid less were given 3 times their pay for the period of 3 months they were there. Further observation that a key professional HR person must take care of is that you need to prove valid reason and follow due process, please, at all times. Valid reason must exist, fair process must be followed. And the outcome was declared termination was unfair. That is that case 3. And I want to move to case 4, because these cases now amplify what we have talked about through Mr. Andrew. The last case is that of Oyombe versus Economic and Social Rights Center, 2025. Another very interesting case. Oyombe was an employee of Economic and Social Rights Center as a fixed term employee. He was given employment for 1 year, fixed term. But even though the employment was to run for fixed term of 1 year, he was placed on probation for 3 months. Now, within the time after probation, within that 3 months after probation, the employer did not terminate the contract. Sorry, the employer did not confirm him. Neither was his contract terminated. And I want us to be very clear here. The fixed term contract was for 1 year for Oyombe, but he was placed within that 1 year, he was placed on probation for 1 year, for 3 months. 3 months elapsed, the probation period elapsed. And the employer did not confirm Oyombe. Neither did the employer terminate the contract. But Oyombe continued to work. However, the terms of the fixed term contract that he entered into required that he was to enjoy certain benefits. He was to enjoy certain benefits. His salary was supposed to be increased as per the agreement. He was supposed to be given pension. He was supposed to be given medical cover, etc. Remember, the probation period ended. The contract was not terminated. Neither was he confirmed. This period continued. And in as much as it continued, the terms of the contract and benefits that Oyombe was supposed to receive from the employer were not affected. His salary was not increased as per the agreement. His pension was not given by the employer as required. Even the insurance and the employer was supposed to pay on his behalf was not affected. As a result of all this, Oyombe resigned. He resigned by himself. After resigning, he went to court, saying that he was forced to resign because of circumstances existing at the place of work. It was not his voluntary resignation. That the conduct of the employer of not increasing his salary as per the agreement, of not paying his pension contributions, of not paying in his insurance, amounted to constructive dismissal, which Mr. Andrew was talking about earlier. And it mentioned it very clearly that constructive dismissal arises where the conditions at work are not conducive for an employee to continue to work. Having these facts in place, the court asked certain questions that upon the expiry of the probation period, was there automatic conversion of probationary contract to permanent to fixed term contract as per the contract originally entered into? Remember, the employer did not terminate the agreement, neither did the person extend even the probation period, but the Oyombe continued to work. Question number: was there failure on the part of the employer to comply with the contract terms entered into with the employee? And number 3, was the employee Oyombe entitled to remedies? These are the 3 questions that were before the court. Upon looking at the evidence that was adduced, the court made the following observations. 1, that upon the expiry of the probationary period of 3 months, and with the employer's conduct of not renewing the probation or terminating the contract, the continuation of Oyombe to work automatically converted the probationary contract into a fixed term contract. Number 2, that having converted probationary contract into a fixed term contract by law, Oyombe as an employee was entitled to be given increase in salary as per his contract with the employer, pension contributions from the employer, insurance contributions from the employer. All this, remember, the employer failed to implement. The court further said that this resignation by Oyombe amounted to constructive dismissal by the employer, which by extension amounts to unfair termination. And the court further said that Oyombe is entitled to remedies for unfair termination. And the court awarded him amounts of money that he would have earned for the entire 1-year contract. This is a serious lesson to employers, HR professionals, particularly where there is probationary contract, and also what Mr. Andrew mentioned earlier, constructive dismissal, where the circumstances and conditions existing at work makes it impossible for the employer-employee relations to continue, thereby leading the employee to leave the place of work, whether by resignation or otherwise. So HR professionals here, key lesson: you must take serious note of breaches that can amount to constructive dismissal. And again, if you have somebody on probation as an employee, very simple. If the probationary contract expires, this was for 3 months, you can extend it. But remember, you cannot extend beyond 12 months, 1 year. Immediately it expires, terminate it. You can terminate the contract, or you can confirm the person. If you fail to terminate the contract and confirm the person, then automatically by law, the person becomes, if it was a permanent and pensionable contract, the person becomes a permanent and pensionable employee. If it is like the case of Oyombe, which was a fixed term contract, then Oyombe becomes a fixed term employee. These are the lessons that we need to learn, implement in our policies, observe when we are dealing with disciplinary matters, whether the employee has misconducted him or herself, whether the employee, it's a case of poor performance, or it's a case of incapacity. Remember, incapacity here may be physical, it may be mental, even though the law actually talks more of physical incapacity. Incapacity is not only physical. These are the cases that are there for you to do further research. And even if you go to the precedents of courts, you will find them under ELRC cases and more. Now, just want to move a bit. I'll allow you to ask questions.
Thank you,
later.
Mr. Bonyo.
Yes.
Am I allowed to ask a question? Unfortunately, I can't see a button of raising a hand on my screen. Sorry. Yeah, thank you very much for that very informative session and taking us through the cases. Maybe I missed out on something on case 3 of Almondi and 9 others versus Brava on the issue of unfair pay.
Yes.
I just want to understand, in circumstances where we have a pay grade, and within that pay grade, we have pay steps, like we have, let me just pick an example of having a pay grade where, let's just use an example of a human resource officer whose minimum pay in that pay grade is, let's say, 150,000, and the maximum pay is, let's say, 250,000. And then we have one employee who's worked for like 5 years, and over these 5 years, they've gotten the merit increment over the years. They've also gotten the cost of living adjustment for these years, and their pay has gone to, we give an example of 230. And we have this other employee who is just coming, maybe he or she's just 1 or 2 years, and their pay is at 160. And can we treat that as a case of unfair pay? Because this one has been there for 5 years, they've earned all these increments, merit increment, cost of life adjustment. And then we have this one who's just come in there like 1 or 2 years, and their pay is at 60, but they are doing the same job. Thank you.
Thank you very much. Remind me of your name.
My name is Pamela Bateta.
Pamela is asking the question for the benefit of all the participants, that on matters pay, will it be unequal pay in a situation where we have a HR officer who is entering at a level of 150K to 250K? Then another one who just joined and is taken about 2 years is earning 160K. Then one who has been there for 5 years has moved from 150K to now earning 200K. Is that unequal pay for equal work? That is the question she's asking. The answer is no. And I'll give you a reason. There is an amount you receive as salary at the entry level. It graduates as you continue in terms of promotion, in terms of every year. For an employee who has joined as a new HR will earn 150K. The one who has taken about 2 years has now moved from 150 to 160. They're doing the same work. There is one who has stayed a little bit longer, 5 years, and has now moved by graduation internally to 230,000 shillings. We cannot say that a person who is earning 230,000 after 5 years and a person doing the same work who has just joined 1 or 2 years ago should earn the same. These are now graduated pay discussions by the policies of the organization. They are doing same work, but their salaries are different given period served, promotions probably they have obtained in the course of time, etc. It is not an equal pay for equal work. An equal pay for equal work means they joined the same time. A, B, C joined at the same time. They were recruited the same day. But A is getting 10,000, B is getting 12,000, C is getting 20,000. They're doing the same work. That is the unequal pay we are talking about. Not earnings as a result of experience and promotion. No. Thank you. Are you answered?
Thank you very much. Thank you.
Any other question before we proceed?
Yes. First of all, thank you. First of all, thank you for that, Pam, because I was going to ask that as well. Then the other one is a clarification. You say that if somebody is on a probationary contract, one can end the probationary contract provided you stick to the timeline. And I was wondering, must you give a reason in that situation where the probationary contract was probably a 6 month and you've decided you don't want to continue with that person, maybe for behavioral reasons, maybe the person is disrespectful and you're not considering renewing it, can you just end it? Is that okay? Or still have to go through the process of hearing? I am Consulate. Maybe you still go through the process of hearing. Yeah.
Now, the question you are asking for the benefit of the rest is, if an employer decides to terminate probationary contract upon the expiry of that probation period, must the employer give a reason? This is what the Employment Act says. In all cases of termination, the employer is required by law to give reason for termination, except in matters voluntary termination where there is no misconduct. In other words, the employee, there must be a reason why you want to terminate the probationary contract. Probably the person has not met the target, but you are also saying here that, for example, you don't like the behavior of the employee. If there is misconduct in terms of behavior, you must go through the right process of misconduct. And you must give reasons for that misconduct so that the employee is able to defend him or herself. That is the procedure. You must give reasons. The only exception is where, for example, there is no wrong on the part of the employer or the employee. People just want to part ways. There is no wrong on the part of the employer and the employee. And we just want to part ways. Remember, a contract of employment is a voluntary and mutual agreement between the two parties. As we came together voluntarily, the law allows us also to part ways voluntarily, even if there is no wrong on either party. So the employer can terminate, the employee can terminate, so long as there is no reason.
So where there is no reason, you can say there is no reason. You're terminating, but there is no reason.
If you are terminating on probation, you must give a reason. You must give a reason. So let's move to the next item. What are the principles governing case laws? Those case laws that we have looked at, they are actually anchoring their decisions on procedural fairness. You must adhere to procedures strictly. Also, the substantive fairness we are talking about, valid reason, the reason must also exist. And when matters of disputes come, the burden of proving the alleged wrong lies with the employer. The courts are always protecting the employee at all times. The employee is in a weaker position. So whenever you go to ELRC as HR representing the employer or the employer him or herself, know that the court will always act in favor of the employee unless you prove by cogent reason that the employee has conducted himself wrongly and you have followed the right procedure. And the court will always order for reinstatement where the termination is unfair or unlawful. Those are the key elements. Then also make sure the punishment you are giving is in consonance with the wrong committed. If it's a minor offense, don't go for the extreme sanction, and vice versa. If it requires warning, just give warning. If it is gross misconduct that requires immediate termination, do so, but also follow procedure after that. What is the cost of non-compliance? There are several penalties that the employer will face should there be non-compliance. They range from financial penalties like compensation and damages. Damages simply refers to monetary compensation awarded to the employee for the wrong on the part of the employer to terminate the contract. The legal costs are there. Remember the reputation or image of the employer. That is in jeopardy. Disputes do mess with operational functions of an organization, leading to productivity issues like low productivity.
We had lost you. Maybe you can repeat that.
I'm saying, are you getting me now?
Yes.
I'm saying, wherever there are disputes and matters go to court, operations of the organization are normally disrupted, leading to low productivity and poor performance even within the organization. The targets are not met because people are always in court. The employee who was supposed to have worked for you is not there, etc. Even the employee's morale is actually declined or reduced. When you take a colleague to court or a colleague takes you to court because of some unfair process that took place, even the remaining employees are affected. Remember, these employees have also personal relations with each other. Again, when matters go to court frequently for non-compliance, the regulatory authorities under the Employment Act, inspectors, etc., will want to know what is happening here. So they will come in, and they normally come in with sanctions, you'll pay fines and enforcement actions that they carry with them. Then there is the cost of litigation, registering cases, that is filing cases, engaging lawyers, time going to court every now and then. That wastes a lot of time for purposes of productivity in an organization. I've just divided them now into financial consequences. I've just decided to divide them. What are the financial consequences an employer may suffer? In a case where an employee is wrongfully dismissed, the Employment and Labor Relations Court will give up to a maximum of 12 months salary in terms of compensation. The law prescribes 12 months. That is a lot of money, and yet this person is also reinstated. The legal costs are there, including legal fees, court expenses, which are actually significant. There is what we call back pay. When an employee is reinstated, the law requires that you pay that employee even the salaries that the person earned during the period of termination. So you will pay from the beginning, the time of termination up to the current. It's a loss because the employee was not working for you. Fines may be imposed and other penalties. Then there is also productivity loss, as I said. We have already talked about that. Then reputational and operational risks. there is brand damage, publicity, which is negative. This organization is doing this to employees. And once members of the public have negative opinion about their organization, it has ripple effects. Industrial unrest, there may be strikes, lockouts, thereby interfering with the progress of the organization. Regulatory scrutiny, I've just talked about it, where the authorities will now monitor what the organization is undertaking. That normally leads to disputes. You cannot also not be able to attract serious talents because they don't want to join an organization which has issues with employees. So talent attraction becomes an issue. Even management distractions in terms of time spent handling disputes diverts focus from strategic organizational priorities. Those are the reputational and operational risks. Legal and strategic risks. Adverse precedents. Normally, judgments of courts sometimes cast adverse aspersions on the parties. These ones affect organizations. Those precedents will be followed and will affect the organization. Policy weakness. When there is weakness in policy, it indicates non-compliance with the legal framework and therefore gives problems to organizations. There will be increase in claims, and who bears the claims? Who bears the consequence of paying the claims? It is the organization. Again, weak compliance strengthens union bargaining. They will be pushing for more and more, and that has financial and legal implications on the employer. There is business uncertainty where people are not focused on matters organization, but matters disputes. So HR professionals, you need to comply with that. Now, how do we mitigate the risks that we are talking about? One, develop clear HR policies and align them with the law and the best practices that are there. Number two, undertake frequent audits and review compliance, identify the gaps, and improve processes continuously. Engage your HR teams on capacity building so that they are compliant with the legal requirements, legal procedures. Address issues early, that is early intervention. Whenever a dispute arises, try to deal with it before it moves to another level. It is better because it is less costly. And where you are stuck as a HR professional, please seek legal advice, even if it means going outside there to look for one, if you don't have one in your organization. And again, have employee engagement and involvement at times. It is important that once you engage and involve employees, you more or less like dealing with the same thing in the same manner. So disputes will be reduced. On executive summary, one, you need to understand as a HR professional, it is important that you understand the provisions of the Employment Act and the workplace policies. You must do that. Adhere, that is respect and follow Section 41 of the Employment Act on procedural fairness. Number three, follow Section 43, dealing with valid reason and existence of that reason. Maintain proper documentation. Mr. Andrew talked about those records from notice to show cause, notice to appear, minutes, all that. Apply consistency always. Similar cases must be dealt with in a similar manner. And therefore, make sure that cases that are the same are dealt with in the same manner and the decisions are the same so that there is consistency. Very important, respect employee rights. Because once you do so, their dignity is taken care of and the disciplinary process will be minimized. That is the end of that presentation. And I would like to ask if somebody has a question in respect to what we have discussed so far.
Anybody with a question, please ask your question or make a comment so that we can close.
I have a question on proportionality principle.
Yes.
Let's go ahead, Consulate.
Sometimes somebody has been absent and you go through the hearing, you agree on giving the person a written warning, but also agree that the day is lost because the reason for absence is not valid, will not be paid. Is that a double penalty on the employee? The days of absenteeism have not been paid and the person has got a written warning.
That is not double jeopardy. It is not punishing somebody twice for the same offense, because if a person is absent from work, the law allows the employer to actually deduct an amount equivalent to each day's salary during the period of absence. That is allowed.
Thank you.
Thank you.
So, ladies and gentlemen, if there is no other question or a comment to be made, I think it's now time for us to close. Anybody with a comment?
We would like to say thank you so much for what you've taken us through.
Thank you, Consulate. Anybody else? We really appreciate.
Yeah, I'd like to appreciate both of you. That was a well-presented class. Thank you, Paul Bonyo. Thank you, Andrew Ndari.
Thank you.
Yeah, Judy, thank you very much. We appreciate.
Okay, my name is Kananu.
Yes.
I'd like also to say thank you for the well-presented session. My only concern was those slides. How can we get access to them? Maybe the host can advise.
Thank you, Kananu. These notes are available online in hard copy and the soft form, that is in video form. Once we finish this session, they should be posted on our website. Please use your login credentials and you should be able to access all of them. Thank you.
Okay, thank you so much.
If there is no further question or comment to be made,
thank you very much. Thank you very much, Andrew. Unfortunately, I can't see the raising hand button on my screen, so I'll look for it. So mine is just to say thank you very much. This was a very timely presentation. And some of us, we've grumbled with some of these things. Just when you get to an employee sues the organization, and then you're going back to check, where did I go wrong? Which documents don't I have? And now with this webinar, it's very, very informative. And for me personally, it's just going back and checking, like I have all everything documented. I have everything just in case. You know, we say just in case. You never know what can happen tomorrow. So thank you very much for organizing for this, and thank you to our facilitator, very knowledgeable, and with tunasema asante sana. Thank you.
Thank you, Pamela. Thank you, everybody, for your participation. We really appreciate. SHRP is here for us. Please be on the lookout for our programs starting next week on 4th, all the way to November and December. We shall always be ready and available for you to make such a presentation. Thank you very much. Have a good day, and may God bless you all.
You too.
Be blessed, everybody.
Thank you.
Yes, nice weekend.
Have a good weekend too.